Actually, that would. I don't know if both teams do have a roster that they have the ability to screen share. I don't think it makes any particular difference. As I indicated, it was pretty easy to keep track yesterday of who did what. Oh, and thank you. It looks like Team 3 put that in chats for us as well.
Thank you.
All right. Okay, so I'm just going to go ahead and confirm. Once again, you cannot video record or tape record the proceedings. So I just want to confirm that nobody is in fact recording the proceedings. In this particular case, you can record Zoom, so make sure nobody is recording Zoom or screenshotting the proceedings during the presentation. You must have previous permission to do so. I do want to inform you, though, that the Colorado Bar Association may be taking screenshots or maybe recording portions of the presentation so they can use it in future promotional material. I want to remind everybody that you cannot be present and watching this as a non-team member. If you're associated with this team or associated with any other teams, you cannot be watching other teams' rounds. So just to ensure that if you are in fact, unless you're under the exceptions provided in Rule 4.3, you do need to stop watching the live stream or exit the presentation. I'll remind the team that no recesses will be allowed with the exception of those granted for a health emergency, especially not between the end of witness examination and the beginning of closing arguments. Please contact me via chat, or if it is a significant emergency and you need to pop into the presentation and let me know, please feel free to do that. All right. At this time, I'm going to ask Ms. Cardone, and I indicated that I had seen the previous team before, but Ms. Cardone, it looks like we have Team 3 and Team 4 with their names available. If everyone, I don't know if Ms. Cardone has any concerns about conflicts by names alone, and if you need to see anybody in person, we can do that. But please let me know if you feel that there's any conflicts in scoring the panelists or scoring the participants today.
Thank you. I appreciate that. I've reviewed the rosters and I do not perceive any conflicts at all.
Thank you. Okay, I'll remind the teams that any disputes arising out of the competition must be reported in accordance with competition rules. I'll remind you that compliance with time requirements is considered in scoring individual performances. I'll remind the teams that no coach or team member other than timekeeper is seated in the jury box. And obviously we have a constructive jury box at this point. You cannot electronically communicate or communicate in person with anybody other than your team members that are participating in this round. All right, at this time, I'm going to ask each side to please introduce the team members.
Good morning, Your Honor, opposing counsel, members of the jury. My name is Rachel Kidder, and I, along with my co-counsel, represent the people of the state of Colorado. I'll be giving the closing argument, as well as conducting the direct examination of Detective Jordan Markowitz and the cross-examination of Professor Blake Van Owen. May my co-counsel introduce themselves?
Yes, thank you.
Good morning, Your Honor, opposing counsel, members of the jury. My name is Claire Ann Wind, and today I will be giving the opening statement, as well as conducting the direct examination of Kyle Cusack and the cross-examination of Avery Becker.
Good morning, Your Honor, opposing counsel, members of the jury. My name is Ivan Holtzinger, and I will be conducting the direct examination of Alex Cifuentes and the cross-examination of Taylor Perkins. May the people's witnesses introduce themselves.
Yes, please. Thank you.
Good morning, Your Honor, opposing counsel and members of the jury. My name is Aubrey Pelican, and I am Kyle Cusack.
Good morning, Your Honor, opposing counsel, members of the jury. My name is Soren DeLay, and I am Alex Cifuentes.
Good morning, Your Honor, opposing counsel, members of the jury. My name is Angela Maley, and I am Jordan Markowitz.
Thank you for the defense.
Good morning, Your Honor, members of the jury, opposing counsel. My name is Cindy Nguyen, and I will be performing the opening statement, the direct examination of Avery Becker, and the cross-examination of Detective Markowitz.
Good morning, Your Honor, ladies and gentlemen of the jury and opposing counsel. My name is Maggie Holland, and I will be providing the direct examination of Taylor Perkins, the cross-examination of Alex Cifuentes, as well as representing the Keystone attorney.
Good morning, Your Honor, members of the jury and opposing counsel. My name is Raina Hilden, and today I will be providing the cross-examination of Kyle Cusack, direct examination of Professor Blake Van Owen, as well as the closing arguments. At this time, may our witnesses introduce themselves?
Yes, thank you.
Good morning, Your Honor, members of the jury and opposing counsel. My name is Kaylee Langan, and I am Avery Becker.
Good morning, Your Honor, members of the jury and opposing counsel. My name is Lucy Ingram, and I'm Taylor Perkins.
Good morning, Your Honor, opposing counsel and members of the jury. My name is Sarah Mazer, and I am Blake Van Owen.
All right, thank you so much. At this time, I'm going to swear in team members, the gallery, the scoring panelists, and the witnesses.
Ms. Schulten, I apologize for interrupting. At this point, I think I do need to disclose a possible conflict.
Okay.
Upon introduction of the witnesses, I believe that I may know Ms. Langan's parents, and if I'm correct about her identity, her younger brothers as well.
Okay.
My son used to play on the same soccer team as Ms. Langan's brothers. Candidly, I don't believe this would affect my impartiality in any manner, but I do want to make everybody aware of that and allow them to make appropriate objections and appropriate action to be taken.
All right, thank you so much. At this time, if anyone has an objection to Ms. Cardone as our scoring panelist, can you please lodge it in chat? So for the most part, the objection would either come obviously from Ms. Langan's team, if there's any concern, or from team 4, if there's any concern about Ms. Cardone's ability to fairly adjudicate the proceeding, having familiarity with the family. Okay, just to verify them from, I guess I'm going to just ask then, from team 4, is there any objection to Ms. Cardone? And for this purpose, I believe coaches may step in since we're dealing with a conflict issue and not a substantive issue. For team 4, is there any objection to Ms. Cardone as the scoring panelist?
As long as she remains impartial, we have no objection, Your Honor.
All right, thank you, Ms. Kidder. For team 3, again, coaches may speak up given the nature of this conflict. Is there any objection to Ms. Cardone as the scoring panelist?
No, Your Honor.
Okay. All right. Thank you very much. Then I will go ahead and proceed with the swearing in. All right. For constructive purposes, I'm going to ask that the team members, again, constructively stand up, but do please raise your right hands. All right, team members, do you promise that the presentation you are about to give will faithfully and truthfully conform to the facts and rules of the mock trial competition? Okay, I do see nodding heads. Thank you. Witnesses, do you promise that the testimony you are about to give will faithfully and truthfully conform to your witness statements, that you will not add material facts or opinions which are not contained in the case problem, and that you will follow the rules and procedures of the mock trial competition? Okay, I see nodding heads. Thank you. Gallery members, again, if you'll constructively stand up, regardless, raise your right hands. This includes teachers, attorney coaches, family members, and friends. If you all will raise your right hands, do you promise to represent yourself as positive role model professional sportsmanship during and after this mock trial round?
Yes, Your Honor.
Thank you. And finally, for our scoring panelists, if you'll please raise your right hand. And do you promise to adjudicate the mock trial competition as fairly and objectively as possible in accordance with the facts, procedures, and rules of the mock trial competition?
Yeah.
And Mr. Walsh, I'm just going to jump in. I do see you did raise your hand as part of a scoring panel. Are you part of the scoring panelist, or are you present as a viewer, team member, etc.?
I am a scorer. I have a score sheet.
Okay. So, Mr. Walsh, I don't know if you heard, just procedurally, for the purpose of the presentation, for the judges and scoring panelists to keep their cameras on, so
Okay.
the participants are speaking with us as we are
Okay.
engaging
I
in
wasn't
this.
sure if that included me as well. So I will keep my my video on.
Yes, if you are a scoring panelist, but we can go ahead and mute just so we don't have background noise during that presentation.
Of course.
All right, I think at this time then we are ready to proceed. Does the prosecution have any pretrial matters they'd like to discuss?
Yes, Your Honor.
Proceed.
First, we would request permission under the rules of mock trial to be able to screen share as a way to publish to the jury.
That will be granted to both sides. As you screen share, they are constructively shared with the additional team or the other team, as well as the judge. And then when admitted, they'll be considered published for the jury.
Yes, Your Honor. Next, we request that as soon as an exhibit is admitted into evidence, it may be published to the jury, and we do not have to request every time.
That'll be granted.
Thank you. And finally, Your Honor, we request that the clock be stopped in the event of any and all technical difficulties.
So as I've done in my previous rounds, we'll take this on a case-by-case basis.
Thank you, Your Honor.
So
Nothing further.
Okay. And does the defense have any pretrial matters? Ms. Holland, I do believe you're muted still.
Yes, Your Honor, briefly. Your Honor, we ask that in the event that someone is having technical difficulties, we ask permission for them to turn off their camera momentarily in order for the sound quality to improve.
That'll be granted. That's fine.
No further pretrial matters, Your Honor.
All right. And I apologize, just one moment, and we will start opening statements. All right. Does the prosecution wish to give an opening statement?
Yes, Your Honor. May I proceed?
May.
Motive, mischief, murder. The woman in the case today is a person named Avery Becker, who had a motive to retaliate against the victim, Mackenzie Rackman. The act of retaliation to vandalize the victim's home, a crime known as criminal mischief. In the process of that mischief, the victim surprised the defendant. They struggled, and the victim, Mackenzie Brackman, was murdered. Good morning, members of the jury. My name is Claire Anwind, and today I and my co-counsel represent the people of the state of Colorado. In this trial, we are seeking justice for Mackenzie Brackman. Avery Becker had a vendetta against Mr. Brackman. They hated each other. Mr. Brackman was the coach of a mock trial team, and the defendant was the insolent team member. This relationship deteriorated so fast and so dramatically that it created a recipe for murder. This is what the evidence will show. Mackenzie Brackman was a lawyer who volunteered to help coach the Colorado high school mock trial team. The defendant was on that team, and to the defendant, that team was her entire identity. She thrived on, without preparation, dazzling the jury with her theatrical performance. The coach, on the other hand, demanded preparation and practice. These two headstrong competitors clashed continuously, with Mr. Brackman believing the defendant was arrogant and lazy, and the defendant believing Mr. Brackman was a terrible coach and lawyer. How can we know the defendant was capable of committing such a crime, members of the jury? We know this because this was not the first time something like this had happened. Just weeks earlier, the two had a series of arguments, each one building on the other. It came to a head and they blew up at one another. The defendant's reaction was disproportionate. The defendant caused extensive damage to Brackman's expensive Porsche car. Mr. Brackman caught her in the act of vandalism and, in anger on the spot, threw her off the mock trial team. The defendant was determined to retaliate. How do we know this, members of the jury? We know it from the defendant's own words. First, the defendant told her mother, "I will get back at Brackman if it's the last thing I do." And second, the defendant texted a friend and said that Mr. Brackman was going to be really angry when he sees what I do to his house. I'm going to wait till he's at work, and then I'm going to break in and trash it. Members of the jury, the defendant did just that. This motive of retaliation compelled her to commit criminal mischief by breaking into Mr. Brackman's home. Only something went terribly wrong. Mr. Brackman surprised the defendant. They struggled, and sadly, Mr. Brackman was murdered. It's not what the defendant set out to do, but under the law of this state, what the defendant did constitutes first-degree murder. Today, we're going to call 3 witnesses. First, Kyle Cusack, who is a crime scene reconstructionist and investigator, to testify about the crime scene evidence and how it supports the theory that this was criminal mischief gone wrong. Second, we will call Alex Fuentes, a former classmate and friend of the defendants, who received the text about breaking into the Brackman home. And finally, we will call Jordan Markowitz, the lead detective on this case. She will testify about the evidence and how the cell phone towers placed the defendant's phone near the Brackman home at the time of the crime. The defense will also call 3 witnesses who will not be credible. They may try to blame this crime on some phantom named Blair Rowlands, someone they have no evidence for and who is not even here to testify today. We believe they are going to call Taylor Perkins, the best friend of the defendant. She will say that she and the defendant were together, except there is no evidence to support this friend's story. We believe they will also call a crime investigator. This investigator did no real investigating and never even went to the crime scene. And finally, the defendant will take the stand. She will have to admit that she hated Mr. Brackman, that she vandalized his car, and that she promised to retaliate against him because of him throwing her off the mock trial team. As the prosecution today, we have the burden of proving beyond a reasonable doubt that Avery Becker committed or attempted to commit the crimes of second-degree burglary and first-degree murder. Because that is exactly what the evidence will show, members of the jury. We ask you to find Avery Becker guilty. Thank you.
Thank you. Does the defense wish to give an opening statement?
Yes, Your Honor. May it please the court, Your Honor, members of the jury, opposing counsel. Good morning, my name is Cindy Nguyen, and along with my co-counsel, Raina Hilden and Maggie Holland, we are honored to be representing the defendant, Avery Becker. On March 6, 2020, the Colorado High School mock trial team's head coach, Mackenzie Brackman, was murdered in his own home. My client, Avery Becker, stands here today accused of this crime. But the truth of the matter is that she did not do it. The prosecution jumped to conclusions and fell short in investigating the killer of Mackenzie Brackman. Now, the law provides that all defendants are innocent until proven guilty. The burden of proof is borne by the prosecution, and they must prove my client's guilt beyond a reasonable doubt, which they will fail to do because of their flawed investigation. You're going to see screenshots of text messages between Avery Becker and Alex Cifuentes. However, beware of Alex Cifuentes' bias against my client. Alex was another member on the mock trial team who is not happy with Avery Becker's accomplishments. And today, she stands on the side of the prosecution, claiming that my client sent these messages. You are going to see pictures of cell tower diagrams tracking my client's phone on the day of the murder. However, the mobile device does not represent the whereabouts of my client. These diagrams will prove to be unreliable as my client lost her phone the day before the murder, and the cell tower diagrams cannot pinpoint the phone's location with absolute certainty as they can reach up to 6 miles away. You are going to see videos of a masked intruder unlawfully entering Mackenzie Brackman's home. Now, the prosecution will claim that my client has the same build as this intruder. But the prosecution jumped to conclusions and fell short by failing to investigate another person who has the same build and body shape as Avery Becker, someone with a greater motive, and that person is Blair Rollins. You see, a few months before the murder, Brackman failed to represent a man named Jonathan Rollins against a murder charge, and Rollins was convicted and sentenced to life in prison. From his imprisonment, Jonathan Rollins' child lost a father. This child, Blair Rollins, could be an equal suspect in this case. But once again, the prosecution jumped to conclusions and fell short when they neglected to look into any suspects other than my client. Listen to how the prosecution explains how they investigated the whereabouts of Blair Rollins on March 6th. Without that evidence, members of the jury, you have the basis for reasonable doubt. The defense will call 3 witnesses: Avery Becker, Taylor Perkins, and Blake Van Owen. The defendant, Avery Becker, was a naturally gifted, award-winning attorney on the mock trial team. You will hear that Avery Becker and Mr. Brackman did not have a great relationship. However, while the two did not always see each other eye to eye, they were on the same team, the mock trial team. Our second witness, Taylor Perkins, will testify that Avery Becker was with Perkins the entire day of Mr. Brackman's death. The two went to the mall and the fry shack to retrace their steps and search for the missing phone. Taylor Perkins will testify under oath that Avery Becker has an ironclad alibi for the date and the time of the crime. Our third witness, Blake Van Owen, will dispute the prosecution's claims of how the murder was carried out, and she will question the validity of every piece of evidence that the prosecution brings into today's investigation. Not only was their investigation sloppy, but you'll hear that they lost pieces of evidence as well. Like I said, the prosecution is not interested in the truth. They are simply jumping to conclusions to get a quick conviction. At the end of this trial, my co-counsel, Raina Hilden, will recount the instances in which the prosecution jumped to conclusions and fell short in procuring the evidence presented to you today. Again, in order for my client to be deemed guilty, the prosecution must meet the burden of proof, which is to prove Avery Becker's guilt beyond a reasonable doubt, which they will fail to do. At the end of this trial, we will ask you to rule in favor of the defense and acquit Avery Becker of her own coach's murder. The evidence will show that Ms. Becker is not guilty. Thank you.
Thank you. Does the prosecution want to call their first witness?
The prosecution calls Kyle Cusack.
All right. And Ms. Cusack, you are up on the stand. You've already been put under oath. You may proceed.
Good morning. Please introduce yourself to the jury.
Good morning. My name is Kyle Cusack. That's Kuzak.
Ms. Cusack, what is your profession?
I'm a Colorado Bureau of Investigation certified crime scene reconstruction investigator, but that's a mouthful, so we just use the term CSR.
As a CSR, will you tell the jury what you do?
Absolutely. I investigate complex crime scenes, including home invasions, burglaries, and other property crimes, homicides, domestic violence, fatal accidents, and armed robberies.
How many years of experience do you have as a CSR?
I have 19 years of experience as a CSR.
What have you been doing in your most recent years?
For the last 3 years, I have been a civilian employee for the city of Denver. That means I'm not a certified peace officer.
In the case today, the defendant is being charged with second-degree burglary and first-degree murder. Do you have any experience investigating those types of crimes?
Yes, that is exactly what I do for a living.
Please tell the jury how you investigate and reconstruct crime scenes.
Well, I've actually developed a 5-step process for the purpose of reconstruction and investigation of crime scenes. Those steps involve identifying evidence, collecting evidence, evaluating evidence, creating a hypothesis based on that evidence, and finally, reconstructing the crime scene.
You seem to be very intentional in your investigations. Why is that?
I assume from day one that any crime I investigate will go to court at some point, and for that reason, I am extremely thorough in all my investigations.
Did you use your process to investigate the crimes we are discussing today?
Absolutely.
Your Honor, the people of the state of Colorado offer Kyle Cusack as an expert witness in crime scene reconstruction and investigation.
Any objection or voir dire?
No objections, Your Honor.
All right, she will be admitted as an expert in crime scene, CSR, crime scene reconstruction and investigation. You may proceed.
Ms. Cusack, how did you become involved in this investigation?
I was called to investigate a homicide at 444 South Flower Street in the city and county of Denver, state of Colorado, on March 6th of 2020.
Who was the victim?
The victim was Mackenzie Brackman.
Turning to your 5 steps, how did you identify evidence here?
I created a witness tracking spreadsheet and a physical evidence tracking spreadsheet.
Please turn to Exhibit 17. What is that?
Those are copies of my spreadsheets.
And how do you know?
I personally created Exhibit 17.
Is Exhibit 17 a fair and accurate copy of the document that you created?
Yes, it is.
Your Honor, the people of the state of Colorado offer Exhibit 17 into evidence.
Any objection?
No objection, Your Honor.
All right, Exhibit 17 is admitted and may be published.
Ms. Cusack, the defense alleged in their opening statement that you limited your investigation to Avery Becker. Is that true?
Absolutely not. As Exhibit 17 shows, I looked at 3 suspects. The primary suspect was Avery Becker. The secondary was Alex Cifuentes, and the tertiary suspect was Blair Rollins.
Why did you ultimately focus on Avery Becker?
After the department's investigation, it was clear to them that Avery Becker committed this crime. There was absolutely no evidence whatsoever that anyone...
Can we pause the clock, Your Honor?
I'm going to just give it a second and see if she pops back in, and then yes. Okay. Okay. Continue.
Yes, Your Honor. Let me just ask that question one more time. Ms. Cusack, why did your investigation ultimately focus on Avery Becker?
After the department's investigation, it was clear to them that Avery Becker committed this crime. There was absolutely no evidence whatsoever that anyone else could have been involved.
Please address step 2 of your process, collection of evidence.
I went to the crime scene after it had been processed by the crime lab. I collected the police reports, photographs, several different videos from the ring security devices, and a copy of the official autopsy report.
You said you went to the crime scene. What did you find there?
I observed the doorbells and the video footage. I observed scuff marks near the back door. There was an open drawer with several knives in it, a broken plate near the kitchen table, and there were some small droplets of blood in the hallway leading to the front door. And near the front door where the murder happened, there was a large pool of blood and a bloody chef's knife.
Let's discuss your evaluation of evidence, starting with the ring videos. What did you do?
I watched them.
Please turn to exhibits 10 through 13. What are they?
Those are the links for the ring videos.
And how do you know?
I was at the site and I observed the cameras at the site. I received these videos from Detective Markowitz.
Are exhibits 10 through 13 fair and accurate copies of the videos that you received from Detective Markowitz?
Yes, they are.
Your Honor, the people of the state of Colorado offer exhibits 10 through 13 into evidence.
Any objection?
No objections, Your Honor.
All right, exhibits 10 through 13 are admitted and may be published.
Now, Ms. Cusack, for the sake of time, just discuss exhibit 11 for the jury.
Exhibit 11 shows someone matching the height and build of the defendant in a Halloween mask and gloves entering the residence through the back gate.
Now, will you please address steps 4 and 5 of your process, testing your hypothesis and then reconstructing the crime scene?
Absolutely. After I finished my investigation, I reviewed all the information I collected, analyzed it, and reconstructed the crime scene.
And what did your reconstruction show?
The evidence clearly pointed to a home intruder, most likely a burglar who entered the residence and, not expecting Mr. Brackman to be home, was caught off guard. Mr. Brackman, who had a knife, as evidenced by the empty slot in the knife block and the open drawer, caught the intruder off guard, and as the scuff marks and broken plate show, there were clear signs of a struggle in the kitchen, leading me to conclude that the ensuing struggle resulted in Mr. Brackman being stabbed.
You just testified that Mr. Brackman had a knife. What about the intruder? Did they have a knife with them when they entered?
Although it is possible, the videos show no evidence that the intruder had the knife on them. It would have been extremely difficult to carry that large of a knife in those baggy clothes. I believe that the knife came from Mr. Brackman's knife block.
Why do you believe that?
When I evaluated the crime scene, there was only one empty slot in the knife block, and it happened to be of the right shape and size to store the chef's knife that was used to commit the murder.
Was the knife of the same brand as the rest of the block?
No, the knives in the block were from a more expensive brand.
Did that concern you?
Certainly not. It is reasonable for a person to replace a chef's knife. If, for instance, the original knife had been lost or damaged, Mr. Brackman could have easily replaced it with a similar knife.
Finally, Ms. Cusack, is it your job with the Denver Police Department to determine who committed a crime?
No, my job is to reconstruct crime scenes so that the detectives can find the person who committed the crime.
And through your reconstruction, did you come to any conclusions?
Absolutely.
In your expert opinion, what happened at 444 South Flower Street on March 6, 2020?
This was clearly a planned break-in gone bad. The intruder had knowledge of the victim's property and likely chose a time of day when the victim's patterns would have placed him outside the home. Either Mr. Brackman was alerted to the intruder's presence by the Ring doorbells or by seeing the intruder directly, and he grabbed a knife in order to defend himself, but sadly, his own death resulted.
Did your investigation show anything about whether this was a premeditated murder?
All the evidence
Objection, Your Honor,
suggests...
under Rule 704B, even though Ms. Cusack is an expert witness, she cannot give testimony as to the ultimate issue of what the perpetrator intended.
Response, Your Honor?
Mm-hmm.
That
Yes,
rule of
please
evidence,
respond.
the ultimate issue rule, has to do with whether or not the witness is testifying about who committed this crime, not whether it was a premeditated murder or not. This rule does not apply.
Response.
Your Honor, even if the this answer would not go to the ultimate issue of who had committed the crime, the argument of intent would go outside of Ms. Cusack's field of expertise, being a crime scene reconstructionist, not any kind of psychologist.
Response, Your Honor?
Yes.
Ms. Cusack is simply stating what she saw through the evidence based on her expert opinion. We have qualified her as a crime scene reconstructionist and investigator. Therefore, she is perfectly qualified to testify about her expert opinions on the evidence that she found.
This one's a close call. I'm going to sustain a conclusion as to intent or mental state of the individual involved in the crime. But she can testify in essence to, believing that it was a burglary or believing that it was homicide.
Ms. Cusack, in your reviewing of the evidence, did you come to any conclusions about whether the intruder was aware of Mr. Brackman's presence in his home?
All the evidence suggests that the intruder did not originally intend to kill Mr. Brackman, but his surprise presence in his home, his awareness of the individual, and his attempt to defend himself altered those circumstances.
Thank you. I have no further questions, Your Honor.
Thank you. Cross-examination?
Yes, Your Honor. So good morning, Ms. Cusack. Let's just get right into it. You had testified previously that the knives in the knife block and the one used to murder Mr. Brackman did not match, correct?
Yes, I testified to that.
And let the record reflect that this time the trial technician will display what has been previously marked as Exhibit 7 on the screen. And this is the knife drawer found in Mackenzie Brackman's home, correct?
Yes, it is.
Thank you. And does this accurately reflect what you observed at the crime scene?
Yes, it does.
Thank you. Now, moving to Exhibit 8, if the trial technician could please scroll down. That is the knife block on Mackenzie Brackman's kitchen counter, correct?
Yes, it is.
And the knife that was used to murder Mackenzie Brackman was a Chicago cutlery knife, correct?
Objection, Your Honor, testifying about an exhibit not yet in evidence. If the opposing counsel would like my witness to testify about this exhibit, I request that they first lay the foundation to admit it into evidence.
Response?
Your Honor, I would be happy to admit these into evidence if opposing counsel would like to, and publish to the jury from there.
Okay, let's do that then.
Okay, so do exhibits 7 and 8 accurately reflect what you observed at the crime scene?
Yes, they do.
And you observed these both at the crime scene and the images during your later investigation?
Yes, I did.
Your Honor, at this time, the defense moves to enter exhibits 7 and 8 into evidence.
Any objection?
No objection, Your Honor.
All right, exhibits 7 and 8 are admitted and may be published.
Thank you. Now, Ms. Cusack, the knife used to murder Mackenzie Brackman was a Chicago cutlery knife, correct?
I've already stated that. Yes, it was.
Thank you. And this is a J.A. Heckles knife block, correct?
Yes, it is.
Yet you still concluded that the murder weapon came from that knife block?
As I already said, it would have been very likely for Mr. Brackman to replace the damaged knife that was in that place.
Moving on, if the trial technician could please display exhibit 18 on the screen.
What exhibit was it? I have my exhibits with me.
Oh, thank you. Now, this is an image of the scuff marks in the Brackman residence, correct?
Yes, it is.
And does this image accurately reflect what you observed at the crime scene?
Yes, it does.
And you used this as part of reconstructing the events of the crime, correct?
Absolutely.
Thank you. At this time, the defense moves to enter exhibit 18 into evidence.
Any objection?
No objection, Your Honor.
All right, exhibit 18 is admitted and may be published.
Yes, Your Honor. Now, you have no way of dating these scuff marks, is that correct?
Oh, you can absolutely date scuff marks. You can date anything.
So why then did the investigators choose not to date these scuff marks?
Well, it was very obvious they were just made. If you look at that, it could be easily wiped off with a wet paper towel.
Did you test that theory when you visited the crime scene?
No, that would have obstructed the evidence.
So you did not date the scuff marks nor test if your theory of simply being able to wipe them off was correct?
No, I do not. But it's very
Thank
evident.
you. Now, thank you, but you have no before and after comparison images as to when those scuff marks may have appeared?
No, I do not.
Thank you. And just referring to Exhibit 11, which had been shown to the jury previously and admitted into evidence, there were no identifying physical characteristics of that perpetrator, correct?
I'm sorry, I don't exactly understand what you mean by that.
In the video, you cannot see the face of the perpetrator, any other identifying traits such as their race, gender, age. Is that correct?
Not by the video, no.
Thank you. And you also stated that there was no genetic evidence or fingerprints identifying the perpetrator at the crime scene.
Yes, there was not DNA or hair or anything at the crime scene. The perpetrator had a mask and gloves on. So that would have been very difficult to receive. The only DNA we found from the crime scene was Mr. Brackman's DNA.
Thank you. Now, finally, let the record reflect that the trial technician is displaying Exhibit 17 on the screen, which has been previously entered into evidence. And seeing the annotations here, if you could please look at the first one in the fourth box of the row titled Perkins Taylor. If you could please read along with me. Provided statement whereabouts with S1 on day preceding and day of homicide. Did I read that correctly?
You did.
Thank you. And the second annotation in that same box reads unlocated party, Blair Rollins. Is that correct?
Yes, it does.
Thank you. And this was your expert report, correct?
Yes, it was.
And
this
this acknowledged. I'm sorry. Could you please repeat that?
Yes, that is my Exhibit 17 is my witness information tracking sheet. So yes, it is.
Thank you. So your own report acknowledges that Taylor Perkins provided an alibi for my client.
Absolutely, but she could be lying.
Thank you. But that same report in the same box, the same category, acknowledges that Blair Rollins, another suspect, remained unlocated.
Yes, it did. She very easily could have moved. We just don't know where she went.
But she disappeared very quickly after the crime, which we are in court for today. Is that correct?
I'm sorry, what? Could you please repeat that?
Blair Rollins essentially disappeared from the state of Colorado after Mackenzie Brackman's
Objection,
death.
Your Honor. Lack of foundation and speculation.
Response?
Yes, Your Honor. As an investigator on this case, Ms. Cusack would be expected to have knowledge of the other suspects. In the same report, she acknowledges Blair Rollins as a possible suspect who remained unlocated.
I'm going to overrule it. The witness herself indicated that Ms. Rollins could have moved, so I think it's a fair follow-up question based on the witness's response. So overruled.
Right. Would you like me to repeat my question, Ms. Cusack?
Please do.
Thank you. So Blair Rollins essentially disappeared from the state of Colorado after Mackenzie Brackman's murder. Isn't that true?
I have no idea where Blair Rollins is. She could be anywhere. She could be down the street, but there wasn't enough evidence to convict Blair Rollins of this crime.
But Blair Rollins was never investigated, correct?
Oh, I investigated her. I looked for her. As my Exhibit 17 shows, I looked for her. She's one of the witnesses that we could not find. Unlocated party, Blair Rollins.
Thank you. No further questions, Your Honor.
Any redirect?
Yes, Your Honor. Ms. Cusack, just to be clear, is it your job with the Denver Police Department to determine who committed the crime?
No, my job is to investigate and reconstruct crime scenes so that the detectives can find the right person who committed the crime.
And were you aware of Blair Rollins' location before the crime?
I was not.
So do you have any idea whether or not she could have moved?
I do not know that, no.
Thank you. No further questions, Your Honor.
Based on those questions, do you have any recross?
No, Your Honor.
All right, thank you. At this time, Ms. Cusack, you may step down and this witness may be excused. Does the prosecution have any additional witnesses?
Yes, Your Honor. The people of the state of Colorado call Alex Cifuentes.
All right, and Mr. Cifuentes, if you want to take this stand, you've already been sworn in and you may begin.
Good morning. Please introduce yourself to the jury.
My name is Alex Cifuentes, and Cifuentes is spelled Sifuentes.
Mr. Cifuentes, do you know the defendant?
Yeah, Avery and I have been best friends for years.
Your Honor, the people request that the defendant briefly turns on their screen for the purposes of an identification.
That's granted. If Alex Becker would please turn on their screen for identification purposes.
Mr. Cifuentes, do you see the defendant on your screen?
Yes, I do.
What color is her shirt?
Black.
Your Honor, let the record reflect Mr. Cifuentes has identified the defendant as Ms. Becker.
The record will still reflect.
And the
Ms.
defendant
Becker
may turn off
may
their screen at this
turn her screen off.
Mr. Cifuentes, where did you spend the most time with the defendant?
We were both on the Colorado High School mock trial team.
Why did you join the team?
It was actually Avery who convinced me to try it out in the first place. It sounded super cool.
As you know, the defendant is on trial for the murder of Mackenzie Brackman. Did you ever have any opportunity to see the defendant and Mr. Brackman interacting with each other?
Yep, all the time.
In what context did you see them interacting?
At our mock trial practices and competitions.
How would you describe their relationship to your perception?
It was terrible. They were always really frustrated with each other and for sure hated each other.
Did you ever see any actual conflict between the two of them?
Yes.
Objection, leading question.
Your Honor, this is not a leading question. I merely asked if he saw any conflict between the two of them. This doesn't imply the answer in the question.
Overruled.
Let me repeat the question. Mr. Cifuentes, did you ever see any actual conflict between Mr. Brackman and the defendant?
Yes. One day when Avery was late for practice, again, Mr. Brackman got big mad.
What happened after Mr. Brackman got so mad?
He demoted Avery to the B team.
What happened after the defendant got demoted?
Taylor Perkins, who was good friends with Avery, quit the team. That forced Mr. Brackman to put Avery back on the A team.
How did the team do after that?
At regionals, we advanced to state. Avery won Best Attorney and Best Closing Argument awards.
Did these awards make things better between the defendant and Mr. Brackman to your perception?
No way. Just the opposite. At the next practice, Mr. Brackman was super critical of Avery for not preparing, despite the awards.
Did Mr. Brackman's comments have any impact on the defendant that you perceived?
Yeah, Avery got super pissed.
Objection, Your Honor, speculation.
Your Honor, Mr. Cifuentes isn't speculating to anything. He is testifying about what he observed on a mock trial practice, and he is allowed to testify about this under Rule 701, opinion testimony by a lay witness. Since Mr. Cifuentes is not testifying as an expert, his testimony of opinion is limited to one that is rationally based on the witness's perception of this argument between the defendant and Mr. Brackman. It is helpful to clearly understand the witness's testimony about this situation and is not based on scientific, technical, or other specialized knowledge of someone who is qualified as an expert under the scope of Rule 702. Therefore, Mr. Cifuentes isn't speculating to anything, and this is an exception under Rule 701.
Thank you. I'm going to overrule the objection as long as his testimony is stating specifically what he observed and not what he believes a person is feeling or thinking.
Let me repeat the question, Mr. Cifuentes. How did you observe the defendant to react when Mr. Brackman commented on her?
She got super pissed and left practice.
What happened after the defendant left practice?
The defendant, after she left practice.
Did anything happen on her way out?
Yes, I saw her grab a permanent marker on the way out, which seemed kind of odd.
What happened after she grabbed a permanent marker?
Mr. Brackman had a dope car, a 1986 Porsche 911, and Avery wrote Worst Attorney Award in permanent marker on it.
What happened after this act of vandalism?
He kicked Avery off the team completely.
What happened after the defendant got kicked off the team?
I'm sorry. You please question that.
Would you like me to rephrase? How did the defendant respond to being kicked off the team to your perception?
She texted me shortly after she was off the team and asked if I would talk to Mr. Brackman about having her back on the team.
Did you talk to Mr. Brackman about that?
Yes, I went to Mr. Brackman and pleaded with him to let Avery back on the team.
Did Mr. Brackman let the defendant back on the team?
No, he refused to.
After the vandalism incident and Mr. Brackman kicking the defendant off the team, did you communicate with the defendant in any way?
Yes, by texting.
Please turn to what has been marked as Exhibit 14.
Okay.
What is it?
It's a text conversation between me and Avery.
How do you know?
I was the one who captured these screenshots.
Are these screenshots a fair and accurate copy of the screenshots that you took of your conversation with the defendant?
Yes, they are.
How do you know it was the defendant who was texting you and not some random person?
Well, we have texted many times. Her number was saved to my phone, and we were talking about things personal to her that only she would know.
We believe that the defense is going to ask whether these screenshots were manipulated or doctored in any way. Did you manipulate or doctor these screenshots in any way?
No way. I don't even know how to do that.
Your Honor, the people of the state of Colorado offer Exhibit 14 into evidence.
Any objection?
Yes, Your Honor, I have 3 objections. Under Rule 801, this document is hearsay because it is an out-of-court statement. Under Rule 901, authenticating evidence, the proponent has failed to produce sufficient evidence aside from the claims of Mr. Cifuentes that Avery Becker is indeed the one sending these messages. And under Rule 1002, requirement of the original, this is in fact a screenshot of the text messages and therefore not the original.
Your Honor, this is not a hearsay document because we've already established that these are the text messages that Mr. Cifuentes sent to the defendant, and it is therefore an exception to hearsay. Under Rule 801D2, these statements are statements by party opponent on the defendant's side. Second of all, due to lack of foundation, or what was your first objection?
My objections in order were under Rule 801 hearsay, Rule 901 authenticating evidence, and Rule 1002 requirement of the original.
Your Honor, foundation has been laid that these are authentic documents because Mr. Cifuentes has already testified as to the fact that the defendant has sent these text messages to him. They were not manipulated or doctored in any way. And if the opposing counsel had any objection to this, then this testimony would not have gone in. Therefore, these are authenticated documents because the testimony's already laid the foundation that they are authenticated. As to 1002 best evidence rule, best evidence rule requires that the original writing, recording, or photo is required to prove contents unless these rules or federal statute provides otherwise. However, Rule 1003 says that a duplicate is admissible, same as original. And if we had the originals, then they would be presented today. As we don't have the originals, these screenshots are sufficient and they do not fall under best evidence rule because they are the best evidence presented.
All right, thank you. Under the hearsay exception, I am going to allow the statements in that are statements of the opposing party or statements of the defendant, I should say. As for the remaining statements that appear to be from Mr. Cifuentes, I don't believe they're being offered for the truth of the matter. So pursuant to hearsay, I will overrule the objection. Authenticity, at this point in time, the prosecution is indicating that this is what they purport it to be. Given the standard required for authenticity, Mr. Cifuentes has identified these as text messages he's received and identified himself as the receiver and author, identified Miss Becker as the one that sent it based on his knowledge of the phone name identified. As such, I will overrule it on authenticity, and I will further overrule it on the best evidence rule pursuant to 1003. So at this time, I will admit Exhibit 14 over defense objection, and you may publish it for the jury.
Mr. Cifuentes, in what color are your words on the exhibit?
They are green.
When the defendant asked you to talk to Mr. Brackman about letting her back on the team, how did you respond?
I guess I could try, but after the car situation, I doubt anyone could change his mind.
How did the defendant respond when she found out she wouldn't be let back on the team?
Well, if he's still upset about his car, then he's going to be really upset when he sees what I do to his house.
How did you respond to that?
I was kind of confused, so I texted her back and asked what that meant.
Did she tell you what that meant?
Yes, she said, I'm going to wait until he's at work, then break in and trash it. That'll show him.
Mr. Cifuentes, how did you become aware of Mr. Brackman's murder?
Some detective called me about it.
What did the detective want?
The detective wanted to talk with me and also wanted screenshots of the text conversation between me and Avery.
What did you do after talking to the detective?
I had the screenshots on my phone and I emailed them to the detective.
Did you also talk to anyone who worked for Avery?
Yeah, Avery had some sort of weird private investigator try to talk to me. I didn't want to, but she insisted.
How did that go?
It was just awful. She tried to get me to lie. She wanted me to say that I faked a text conversation with Avery, which I obviously didn't.
Mr. Cifuentes, later we'll hear allegations that someone stole the defendant's phone. Did you steal the defendant's phone?
No way.
Leading question.
Your Honor, this is not a leading question because it doesn't assume the answer of the question within the question. I merely asked whether or not he stole the defendant's phone. I did not imply the answer within the question.
I'll overrule the objection.
Let me repeat the question, Mr. Cifuentes. Did you steal the defendant's phone?
No way. Why in the world did I do that?
Finally, did the defendant have a reputation among the mock trial team?
Oh, yes, she did.
What was that reputation?
Avery had a reputation for laziness, always being late and never coming prepared for practice or the tournaments. She also had this reputation to do this crazy thing as a witness where she made things up and convinced the judge and jury that it was completely true.
Thank you, Mr. Cifuentes. No further questions.
All right, thank you. This time, both timekeepers stop your time. Okay, both timekeepers have stopped their time. I'm going to, in essence, do a constructive bench conference regarding time. There appears to be a discrepancy in the time. Can the two timekeepers please identify yourselves and let's discuss our time.
Yes, Your Honor. I am the timekeeper for the defense, Team 3.
I'm the timekeeper for the prosecution, Time 4.
I'm going to hear from Team 4.
All right, so I noticed there was a bit of a time discrepancy and we were messaging about it. And for the admitting of evidence, we realized the difference in how he kept time is whenever the lawyer or attorney addresses the judge, I always pause the time until the objections and that was all cleared, and I would resume the time when the line of questioning resumed. So I was wondering if that was the practice we were supposed to follow or not.
And timekeeper 3, I will have to go to the rules regarding timekeeping. My understanding is that time for objections, extensive questioning by the presiding judge will not be counted as part of the allotted time. Time does not stop for the introduction of exhibits. So when a team is introducing the exhibit, time should not stop. If there is an objection to the introduction, then the time will stop. If the attorney, as I read this, and I'm happy, of course, to take argument both sides, if an attorney begins their objection, time would stop. My response to the objection, time remains stopped. And once the objection is ruled on, time will begin again. So during the time the attorney is making the objection, I do believe it appears time stops. It indicates time for objections will not be counted. Does that clarify your question?
Yes, I believe so.
And timekeeper 3, do you have any comment on the way that time is being kept at this point?
No, Your Honor.
Okay. Are you able to recount or recalculate your time?
We can resume with Team 3's time.
Okay, and can you please identify what Team 3's time is then?
Of course, the time for the direct prosecution is 9 minutes and 45 seconds.
Is that a fair time frame for you, Team 4?
I believe so.
Okay, are there any objections to the time that has now been, there was a discrepancy in time. We have taken a moment to address that discrepancy. It appears that they're both on the same time at this point. Is there any objection by either team? If so, please lodge it in chats now. Okay, I do not see any further objections. There is a request for time for defense. So if we can go ahead and verify that our times are correct and there's no discrepancy between the times calculated by Team 3 and Team 4.
Your Honor, I have the time 12 minutes and 50 seconds for cross-examination.
Your Honor, I have the time of 13 minutes, 16 seconds, but I think that's due to also pausing whenever the judge was addressed with the exhibits published. So I think we can go with the defense this time as well.
Okay, so my understanding, Team 4 then, is that you are accepting Team 3's time for the remaining defense cross-examination.
Yes, I am.
Okay. Once again, if there's any objections to time discrepancy issue with the fix that we have discussed on the record, please lodge that objection now. Okay, at this time, it appears both Team 3's time and Team 4's time is back on track. There's no longer a discrepancy. So given the time issues have been resolved, we will resume the presentation of this trial.
Thank you, Your Honor.
Thank you to the timekeepers. And back to Ms. Holland. Ms. Holland, do you wish to cross-examine?
Yes, Your Honor. Good morning, Mr. Cifuentes. Let's start by talking about the defendant. You know Avery Becker from your high school mock trial team, is that correct?
Objection asked and answered.
Overruled. Overruled that objection.
Mr. Cifuentes, I believe you're muted.
Could you repeat the question, please?
Let's start by talking about the defendant. You know Avery Becker from your high school mock trial team, correct?
Yeah, you've been on the team for years.
4 years, is that correct?
Yes.
I understand. You were a hardworking member in mock trial, is that correct?
Yeah, I worked very hard and I loved it.
And you took it very seriously, yes?
Yes.
You don't think Avery worked very hard in mock trial, do you?
She never really came prepared for the practices or tournaments.
And despite her unpreparedness, she frequently received awards, correct?
Yeah, she won Best Attorney and Best Closing Argument awards.
And this bothered you, yes?
Objection relevance.
Response, Your Honor. This goes towards the relationship with the defendant and potential bias and with Mr. Cifuentes. I believe this is incredibly relevant to the case.
I'll overrule the objection. You can ask.
Repeating the question, this bothered you, didn't it, Mr. Cifuentes?
Yeah, a little bit because she didn't really work hard to win those awards.
And this lackadaisical attitude, as you put it, bothered Coach Brackman as well, didn't it?
Oh, yes, it did.
To the point that Avery was kicked off of the team?
She got kicked off the team for vandalizing his car.
But yes, Avery was kicked off of the team by Mr. Brackman.
Yes, because she vandalized his car.
And you were glad Avery was kicked off of the team, weren't you?
I wasn't necessarily glad that my best friend was going to be off the team, but I was excited for the larger roles.
With these opportunities, you would say that your role in mock trial would improve in the absence of Avery and the A team.
Yes, I would get a larger role.
Avery texted you asking to speak to the coach on your behalf. Is that correct?
Yep.
But you do not have these texts?
We have the screenshots.
But you have fallen short in producing your phone with the original texts, haven't you?
Oh, we have the screenshots.
Are these the original phone texts?
They are the screenshots of the original text.
Are they the original texts, Mr. Cifuentes?
Yeah, they're the original screenshots, the screenshots of the text.
This is a yes or no answer, Mr. Cifuentes. I'm asking you, are they the original texts?
Objection, Your Honor, asked and answered.
Response, Your Honor. I believe that Mr. Cifuentes has not adequately answered this question. They are not the original texts.
Even if Mr. Cifuentes didn't give an answer that opposing counsel wants, he gave a yes or no answer. And so therefore the question has been answered. If opposing counsel would like to impeach, then they may do so, but this is still asked and answered.
I'll overrule it. You can ask again, but then let's move on.
I can move on at this moment, Your Honor. You have never showed these texts to law enforcement?
The screenshots, they have those.
And you traded your phone in a few months ago?
Yeah, my old phone got really old, and so yeah.
Knowing that your former classmate was facing trial for first-degree murder?
What do you mean?
You traded your phone in a few months ago, but the time of the murder was well before this. You were aware that the murder had happened, and yet you traded in your phone?
Yes, I was aware. I don't think that has anything to do with me trading in my phone.
It may, though, if you knowing that your previous phone may have contained exculpatory evidence. Yes?
Objection, speculation. Opposing counsel is asking Mr. Cifuentes to speculate as to the grounds of the admissibility of his text messages, and this is knowledge outside of the scope of his witness statement.
Response, Your Honor?
Yes.
I believe that these text messages implying the intent of the defendant, Ms. Becker, it does not require Mr. Cifuentes to speculate that he had these text messages and yet he traded in his phone.
Your Honor, opposing counsel is asking Mr. Cifuentes to testify as to the admissibility of his text messages indirectly because they're asking him whether or not it would have been helpful for the text messages to remain on a phone for a trial, but this isn't outside of his personal knowledge because he's not a criminal attorney. He doesn't know the weight of admissibility of his text messages, and so therefore he's merely speculating as to the weight of these text messages and this situation.
Okay, I understand your objection. I'll overrule the objection at this time.
Repeating the question, knowing that your previous phone had contained exculpatory evidence, you still traded it in, yes?
I traded in my phone.
And speaking of phones, Avery let you play a game on her phone at the Fry Shack the night before the murder, correct?
Yeah, she got a new game and she let me play.
And this was the same night that she lost her phone?
I think so.
And you and Avery have texted back and forth in the past, correct?
Oh yeah, we were best friends, so we texted all the time.
So Avery was a saved contact in this phone?
Yeah.
I would like to turn your direction to what has been published as Exhibit 14, allowing my trial technician to screen share. If you will read along with me, the first line in that text, "Hi, Alex, this is Avery." If Avery was a saved contact, she wouldn't have needed to identify herself, would she?
Objection, speculation.
Response?
I believe I've laid the foundation that they have, Miss Avery Becker and Mr. Cifuentes have texted back and forth and would understand the nature of their texting.
Your Honor, opposing counsel is asking Mr. Cifuentes to testify as to the grounds of the defendant's own text message. He does not know the intent of opposing counsel's text message because he is not opposing counsel. So therefore, he's merely speculating as to the grounds of why she sent that text message, and this is speculation.
I'll overrule the objection. If he doesn't know why she identified herself, he can certainly answer that. So I'll overrule it.
All right, repeating my question. If Avery was a saved contact in this phone, and being that you have texted back and forth, she wouldn't have needed to identify herself, would she?
I don't know why she did that. She could have needed to. She could have wanted to.
There is no timestamp on these texts either, correct?
I don't believe so. Now you can see in the screenshots.
No date stamp either?
I don't think so. I can't see the screenshots anymore, but
no further questions.
Time 3:06.
No further questions, Your Honor.
Thank you. Any redirect?
Yes, Your Honor. Mr. Cifuentes, does Avery's getting better mock trial roles impact your testimony today in trial?
No way.
And did you manipulate or doctor these text messages in any way?
No, I have no idea how to do that.
Thank you, Your Honor. No further questions.
All right. Based on those questions alone, any recross?
No, Your Honor.
All right, thank you. Mr. Cifuentes, you may step down and this witness may be excused. Does the prosecution have any further witnesses?
Yes, Your Honor. The prosecution calls Detective Jordan Markowitz. But before I begin, may I get a brief time check?
I have 9 minutes, 30 seconds on my clock, but I would like to confirm that.
I have the same as well.
Thank you.
All right, thank you. Detective Markowitz, you may take the stand and prosecution may begin.
Good morning. Please introduce yourself to the jury.
Good morning. My name is Jordan Markowitz, and my last name is spelled Markowitz.
Ms. Markowitz, what do you do for a living?
I'm a homicide detective with the Denver Police Department.
How long have you been with the Denver Police Department?
Oh, let's see. I've worked in the police department for around 13 years, and I've been a detective for 7.
Besides all the training and certification that you received as a police officer, do you have any specialized training that you use in your detective work?
Yes, in fact, I have specialized training and certification with cell phones.
Please describe that.
I have a cell phone technology and forensic data recovery certification from the American Academy of Law Enforcement.
What were the requirements for you to receive this certification?
Well, I had to complete a 3-day training course as well as pass a certification test, where I learned about different types of cell phone data, records, and how to use forensic software. I also had to learn how to download the contents of a cell phone, as well as how to acquire and interpret cellular data and records.
Detective Markowitz, how often do you use this training?
Constantly. In this day and age, cell phones are a crucial part of any investigation I conduct. I've downloaded the contents of hundreds of cell phones, and I've obtained and interpreted cell tower data in over 50 cases, I'd say.
And just to wrap up your qualifications here, did you have any involvement in this case today?
Yes, ma'am. I was the lead detective on the case of Mackenzie Brackman's murder.
Your Honor, the people of the state of Colorado offer Detective Jordan Markowitz as an expert witness in criminal investigations with a subspecialty in cell phone technology.
Any objection or voir dire?
Your Honor, I have no objections to Detective Markowitz being admitted as an expert in criminal investigation. However, I object to the specialization in the field of cell phone technology, as I believe that only 3 days of training is not sufficient to prove that the witness is specialized in this field.
Response, Your Honor?
Response? Yes.
Thank you. Under Rule 702, a witness may be qualified as an expert via means of knowledge, skill, experience, training, or education. The length or in-depthness of any of these is not required.
All right, thank you. At this time, I will overrule the objection. I will admit Detective Markowitz as an expert in crime scene investigation with an emphasis in cell phone technology. You may proceed.
Detective Markowitz, you just testified you were the lead on the Brackman case. Will you tell the jury how the case even began?
Of course. So on Friday, March 6, 2020, we got a call from a motorist about someone who had appeared to be passed out on their front porch. We sent some medics down to see what was going on, but upon arriving, they found the victim was actually dead. That's when I was called at the scene of the crime, and I arrived around 2:20 p.m.
When you arrived, what did you notice?
I saw that the front door was wide open, as well as the victim was lying face down just inside the house in a pool of his own blood. There was blood spatter on the walls, as well as a large bloody knife on the floor just past the victim's body.
Detective Markowitz, please turn to what have been marked as Exhibits 1 and 3. Do you recognize these exhibits?
Yes, I do.
What are they?
These are pictures of the victim's body.
How do you know?
Because I observed this body at the crime scene I was sent to investigate on March 6, 2020.
Are Exhibits 1 and 3 fair and accurate depictions of the victim's body in the crime scene on March 6, 2020?
Yes, ma'am, they are.
Your Honor, the people of the state of Colorado offer Exhibits 1 and 3 into evidence.
Any objection?
Yes, Your Honor. Under Rule 403, I would like to object to Exhibit 3 as it should be excluded for being cumulative and more prejudicial than probative. It offers no value that Exhibit 1 doesn't already cover, which is a waste of time. And the additional image of the deceased are simply trying to affect the jury's emotions.
Response, Your Honor?
Yes.
These are two very clearly different pictures showing very different angles. We would like to give the jury a more in-depth description of what happened at the crime scene so that they can visualize things better and understand what we're talking about more clearly. As to the prejudicial part of it, we have to prove that someone died in this case, and so showing photos of the body proves that for us.
All right, thank you. At this time, with the objection noted, I will overrule the objection and allow the admission of Exhibits 1 through 3. So Exhibits 1 through 3 are admitted, and you may publish them to the jury. Thank you.
Detective Markowitz, please describe these exhibits to the jury, beginning with Exhibit 3.
Of course. So as you can see on your screen, Exhibit 3 is a close-up of the victim's back and the stab wound. And Exhibit 1 is a photo of the victim's body as viewed from the front porch. In the top right portion of this picture, you can also see the Ring doorbell.
Were you able to recover anything from this Ring doorbell?
As you saw during Investigator Cusack's testimony, we were able to recover videos because Brackman had paid extra to keep the security footage. But I'm not going to go into those because she's already discussed those videos in detail.
What did you do after assessing the front of the house?
I went around to the back of the house where I observed 2 Ring security cameras. There was one facing the fence and the other facing the back door. Then I went into the kitchen.
What did you see in the kitchen?
There were scuff marks by the back door indicating there could have been a struggle, as well as an open knife drawer and a knife block on the counter with one knife missing. By the table, there was a broken plate, an overturned chair, and drops of blood on the floor, and you could also tell that nothing was missing from the household.
Based on all of the evidence you collected, were you able to form a theory as to what happened in the house that day?
Yes, Mr. Brackman had came upon an intruder breaking into the house and confronted them with a large knife. The intruder gained control of the knife, stabbed the victim, and ran out the front door.
Now let's talk about the rest. Please tell the jury the factual basis for this conclusion.
Well, the videos had made it look like Mr. Brackman had just interrupted a random burglary. The intruder had also entered the house at a time of day that Brackman would have usually been at work. The knife block on the counter with one knife missing, as well as the knife drawer open, also indicates that the victim had armed himself.
Now let's talk about the rest of the investigation you conducted. What was the first thing you did after assessing the entire crime scene?
I began downloading the contents of Mr. Brackman's phone.
Did you find anything of significance?
I found a tremendous number of texts and emails related to mock trial, which is how I found out that Brackman was the coach for Colorado High School's mock trial team. Upon learning this, I reached out to the school to get contact information for all the students on the team. That's when I called one of them and got my biggest break in the case.
Who was the student you called?
Alex Cifuentes.
Did you ever meet with Alex Cifuentes?
Yes, and he showed me the text messages that we saw in Exhibit 14.
Let's pull those up for a moment. Detective Markowitz, what specifically about these messages did you classify as the biggest break in the case?
Well, the defendant basically confessed that her intent was to break in and trash Brackman's house, which is exactly what happened.
Objection, Your Honor.
Yep.
Under Rule 704B, the opinion on the ultimate issue. In a criminal case, the expert witness must not state an opinion about whether the defendant did or did not have the intent to commit the murder.
Response?
Your Honor, once an exhibit is admitted into evidence, it can be used for any purpose. So Detective Markowitz is just outlining what the defendant said in this exhibit.
All right, in this case, I will sustain the objection. She cannot make a conclusion on the ultimate mental state of the sender of the text message. She may comment on the statements contained in the exhibit.
Yes, Your Honor. What was essentially what the defendant said in this exhibit, Detective Markowitz?
She basically said that she was so desperate to get back on, and that if he wouldn't allow her to get back on, she was going to break in and trash the victim's house.
Did you obtain this phone from Alex Cifuentes?
No, I had asked to see it, but he forgot to bring it with him to the interview.
We are most likely going to hear a theory from the defense that these messages were doctored in some way. What is your response to that?
Well, with all my experience as a detective, I would be able to tell if evidence was doctored, and there's no evidence to support that theory.
What did you do once you had seen these screenshots?
I had turned the focus of the investigation onto the defendant. Upon doing so, I learned the defendant was recently kicked off the mock trial team for vandalizing Brackman's car.
What did you do after you did that?
I got a warrant to search Becker's phone, but when I called to make arrangements to search the phone, I found Becker claimed she lost the phone the day before the crime. But I did get the phone number.
Once you got Ms. Becker's phone number, what did you do with it?
I obtained a court order to get account records from Becker's service provider. Then I received these records as well as the call detail records. These records indicate when and where a cell phone reaches out to a cell tower to send or receive a text or call. With these records, I was able to identify the cell towers that the defendant's phone was connecting to receive texts and calls, as well as the duration of those calls.
Based on all of the evidence you collected over the course of this case, were you able to form a conclusion as to the defendant's movements on March 6, 2020?
Yes, the defendant was at home somewhere between 12:45 and 12:50 p.m., then left and drove towards Brackman's house, traveling most likely along Rock Creek Parkway at around 12:55 p.m. Then from 1:05 p.m. to 1:17 p.m., Becker is at Brackman's house.
Taking into account all of the evidence you collected, as well as relying on all of your education, training, experience, knowledge, and skill, were you able to form a conclusion as to what happened in Mr. Brackman's home on March 6, 2020?
Based on all the evidence we collected, the defendant went to the victim's house on March 6, 2020. She broke into the home and was discovered by the homeowner, Mr. Brackman. Mr. Brackman had attempted to use force against the defendant, and Mr. Brackman was killed in the struggle.
Does the evidence indicate that the defendant intended to kill Mr. Brackman?
Objection, Your Honor. Once again, under Rule 704B, the opinion on the ultimate issue, the expert in this case cannot testify to whether the defendant had the intent to come in with murder.
Response, Your Honor?
Yes.
These are conclusions that the detective made over the course of her investigation. She is allowed to testify as to what she did during her investigation, so she is allowed to testify as to these opinions. And she is not testifying to the definitive mental state of the defendant. She is testifying as to what the evidence indicated.
Response, Your Honor?
Yes.
The opinion on the ultimate issue is a matter for the trier of fact alone, and therefore the expert cannot provide her opinion on the intent of the defendant.
Okay. In this case, I am going to sustain the objection. She may testify whether or not she believed that person was responsible for the death, but not the mental state of the individual in essence, conducting the death.
Yes, Your Honor. Detective Markowitz, do you believe that the defendant went to the home that day?
Yes, but I don't believe she was intending to kill Mr. Brackman. It was the middle of the day on a weekday, so it's very logical for her to assume that Mr. Brackman was not at home, but instead at work. It may be that she saw Mr. Brackman with a knife, got scared, and was just trying to defend herself. However, a death did occur, and that is still considered first-degree murder.
No more questions, Your Honor.
Cross-examination?
Your Honor, before I begin, may I get a time check?
7 minutes, 34 seconds.
Thank you.
I have 7 minutes, 39 seconds.
Okay. They're within 5 seconds, so as such, we'll leave it be.
Detective Markowitz, let's walk through your investigation for the jury, shall we? You took pictures of blood on the floor and walls of Mr. Brackman's home, correct?
We had the forensic team take pictures, but they somehow got corrupted, so I don't have those today to share with you.
And so the prosecution jumped to the conclusion today, even when they fell short in collecting evidence that could or could not have exonerated the defendant.
I don't believe that blood spatter went to the effect of if the defendant did it, and I saw the evidence, so I don't say that we don't have this evidence.
So it's your testimony today that... Sorry. Okay. Can you repeat what you just said?
Can you repeat your question then, please?
Yes. The prosecution jumped to the conclusion today, even when they fell short in collecting evidence that could or could not have exonerated the defendant.
Well, first, we didn't fall short in collecting the evidence because I and Investigator Cusack both saw it and know exactly what it looks like, but I also don't think that blood spatter goes to the effect of whether it was the defendant or not.
At this time, I would like to direct your attention to Exhibit 10, the ring video, which has been previously admitted to the jury. Let the record reflect that the trial technician is screen sharing Exhibit 10, and if the trial technician could please stop at 4 seconds. So, Detective Markowitz, you claim that this is Avery Becker?
Yes, all the evidence clearly points to Miss Becker.
And you jumped to this conclusion, even though you don't know the race of the person in this video as pictured?
I did not jump to any conclusions. I do not need to know the race to determine who it was. I oftentimes don't have a to
you please answer my question. Do you know the race of the person in this video?
No, but that is not necessary to determine, excuse me, who it was.
Do you know their age?
No, but again, it's not necessarily necessary because I have all the evidence I need.
You don't know their gender?
Of course not. They're wearing gender neutral clothes and I have all the evidence I need, so it would not be necessary.
However, you don't have concrete evidence besides an approximate height and build that the person pictured is my client.
I do have concrete evidence. I don't need a specific picture of them to have other concrete evidence.
So, however, you don't know if this person is, in fact, Avery Becker.
All the evidence indicates that it is Miss Becker.
And however, this could be another suspect, like you said in your testimony, a disgruntled ex-client of Brackman's.
That was my first thought, but it was highly unlikely upon further investigation.
Now, directing your attention to the call tower records, you noticed incoming calls and texts that weren't responded to?
Yes, they were from Miss Taylor Perkins.
And you jumped to the conclusion that they weren't answered because of what Avery Becker was doing at that time. But wouldn't they be unanswered if the phone were lost?
I didn't jump to any conclusion. I followed the evidence where it took me. And yes, that could be the case, but all the evidence pointed to Miss Becker, so.
And there's no way to determine who is in possession of the phone through the call detail records, are there?
Well, no, because we don't look at their cameras, and of course I wasn't there with her.
It is possible for a cell phone to connect to a tower that is further away, too.
It's possible, but abnormal.
Now, directing your attention to one of your witnesses, you contacted students on Brackman's mock trial team, with your biggest lead coming from Alex Cifuentes?
Yes, that is correct.
And this evidence was text messages between Cifuentes and who she claims is Avery Becker? Or who he claims, my bad.
Yes, but it is, all the evidence points to it being Avery Becker, so I wouldn't say he claimed.
Let the record reflect that the trial technician is screen sharing what has previously been marked as Exhibit 14, the text messages. Detective Markowitz, you asked for these screenshots instead of the text conversations.
Yes, I did.
And these messages say it's Avery, correct?
It appears so, yes.
The contact says Avery.
That is correct.
And you collected Avery Becker's phone number, correct?
I did collect her phone number.
These screenshots don't show that the number is Avery's.
Well, no, because there's screenshots of an iPhone, and iPhones don't show that in the contact itself.
Detective Markowitz, you acknowledge that there are ways to forge a conversation, perhaps through a text conversation app?
Yes, but they are difficult, and I wouldn't expect a teenager to know how to do so.
And it is also relatively easy to change the name of a contact on an iPhone, correct?
It is, but that wouldn't make any sense in this case because, like you said, she identified it was her, so that would be strange.
Just to clarify for the jury, you quickly jumped to accept these screenshots without any further examination or validation that the number is in fact Avery Becker's and that Alex Cifuentes' claims are true.
I didn't quickly jump to any conclusions like you were saying. All the evidence pointed to that was Miss Becker.
However, you did not authenticate that the phone number is in fact Avery Becker's. The phone number.
I would have no way to do so because Mr. Cifuentes forgot to bring his phone, but with all the evidence I have, the screenshots were sufficient.
No further questions, Your Honor.
Redirect.
Yes, Your Honor. Before I begin, may I have a brief time check?
I have 21 seconds on my clock.
I have the same.
Thank you. Detective Markowitz, does blood splatter of the victim provide the identity of the attacker?
No, of course not.
I have no further questions, Your Honor.
Based on that question, any recross?
Yes, Your Honor.
Your Honor, under the rules of mock trial, recross is actually not allowed.
Your Honor, I believe in this trial we are allowed to have recrosses based on the rules.
This time, based on a question, do you have any recross?
Yes, Your Honor.
Go
Detective
ahead.
Markowitz, can you say with certainty that the evidence of blood spatter could or could not have shown to the jury how the murder was carried out and how the knife was entered into the body of Mackenzie Brackman?
Blood spatter would not go to how the knife entered the body of Mackenzie Brackman at all.
Would it be able to show how the knife exited the body?
Well, I've already described that in detail, and I have enough other evidence to show the jury. Plus, I know what it looked like, so pictures of it I just don't think are extremely necessary right now. Plus, they became corrupted, which I have no control over.
So to clarify, this evidence is missing.
It became corrupted, which I have no control over how that happened or why it happened.
Thank you, Your Honor. No further questions.
Thank you. Detective Markowitz, you may step down. This witness may be excused. Does the prosecution have any further witnesses?
The people rest, Your Honor.
All right, thank you. At this time, does the defense have any motions or witnesses?
Yes, Your Honor. At this time, the defense calls Professor Blake Van Owen to the stand.
Thank you. All right, Professor Van Owen, you may take the stand. She's already been sworn in and you may begin.
Excellent. So, good morning, Professor. Can you please state your full name and spell your last for the court?
My name is Blake Van Owen, V-A-N-O-W-E-N.
Thank you. And what is your profession?
I am a private investigator, a professor, and an expert witness in police practices.
And can you please tell us about your experience with law enforcement?
Yes, I worked in the Aurora Police Department for about 9 months, and then I worked as a school resource officer, a private security guard, and then I went into private investigation.
And do you have any educational experience in police procedures?
Yes, I earned a master's degree in criminal justice through Ashford University. I also taught a class on police procedures at the Community College of the Rockies, and a class on police practices and social justice at CU Denver.
Have you ever testified in court before?
Absolutely. I regularly testify as an expert witness in many fields, such as police practices, use of force, false arrest, forensic evidence techniques, crime scene reconstruction, cell tower analysis, and general police investigation tactics.
Thank you. And which courts have accepted you as an expert witness?
I have been accepted as a defense expert in the U.S. District Court for the districts of Colorado, Kansas, and Arizona, and the state courts of Colorado, Wyoming, Nebraska, and New Mexico.
Thank you. And do you have any other experience pertinent to court proceedings and cases?
Yes, I have been accepted as an expert in crime scene reconstruction 8 times, in cell tower analysis 5 times, and in general police investigation tactics 12 times. I've consulted on over 100 cases.
Thank you. Your Honor, at this time, the defense moves to enter Professor Blake Van Owen as an expert in police practices, cell phone tower analysis, and crime scene reconstruction due to her prior experience and expertise in the field.
Any objection or voir dire?
Your Honor, we object on the cell tower analysis portion of that. This witness cannot lay a foundation to having any qualifications in that area.
Response, Your Honor?
Yes.
Thank you. Professor Van Owen has already testified that she has previously been accepted as an expert in cell phone tower analysis 5 times, and she regularly investigates cases such as this one, which do involve cell phone tower analysis. Having been accepted as an expert 5 times obviously shows that she has the qualifications, as well as the fact that she regularly deals with cases such as this one.
Response, Your Honor?
Yes, Your Honor.
Under Rule 702, previous testimony as an expert is not one of the things that she can be qualified under as an expert in this case, and they are not able to tell us about any of her education, training, skill, experience, or knowledge in this area, and therefore she cannot be admitted as an expert in this case under cell phone analysis.
Response, Your Honor?
Briefly.
Thank you. Professor Van Owen regularly investigates cases such as this one, which involves cell phone tower data, and she would be familiar with the systems.
All right, thank you. With that objection noted, I will overrule the objection. I will qualify her as an expert in police practices, cell phone tower analysis, and crime scene reconstruction. You may continue.
Yes, Your Honor. So, Professor, let's move on to the investigation discussed today. What can you tell us about the quality of the police department's work?
After reviewing all of the police reports, the crime scene reconstruction, the cell tower reports, and the exhibits prepared by Detective Markowitz, and conducting my own partial investigation, I can tell you that the police department did a sloppy job investigating this case.
And what makes you say that?
Kyle Kuzak was obviously investigating with a suspect in mind.
What makes you believe this?
Kuzak's investigation was blind to evidence that supported other, even more likely theories. Kuzak pulled pieces of narrative out of the blue with no evidence, such as that the intruder stabbed Brackman with the same knife that Mr. Brackman had retrieved from a knife block in the kitchen just to make her story more coherent.
Thank you. Now, let's move on to Exhibit 20. Let the record reflect that the trial technician is now displaying what has been previously marked as Exhibit 20. And do you recognize this, Professor?
Yes, I do.
What is Exhibit 20?
This is my official report analyzing the investigation done for today's case.
And how do you recognize this exhibit?
I made this myself.
Thank you. And is this a fair and accurate copy of your work?
Yes.
And do you regularly create expert reports such as this when you testify?
Of course, it's part of what I do as an expert witness.
At this time, the defense moves to enter Exhibit 20 into evidence.
Any objection?
No objection, Your Honor.
All right, Exhibit 20 will be admitted. You may publish it for the jury.
Yes, Your Honor. So, Professor, allow me to direct you to the second page of your report. What do you believe is the most likely scenario for Mr. Brackman's death?
Mr. Brackman was sitting, and the intruder behind him stabbed him, holding the knife as you can see in the picture. If Mr. Brackman were standing, the intruder would have had to be much bigger than him, which we can rule out from the ring video evidence.
Thank you. So can you please tell us more about those ring videos you just mentioned?
While Detective Markowitz makes a big deal about the ring alerts, I also have a ring security setup in my own house, and I'm aware of its pitfalls. A user can turn off the push notifications, allowing an intruder to break in without the victim ever being aware. Markowitz did not collect records from Ring to check whether Brackman had his notifications on. Even if he did, he might not have had his phone on him at the time and still would have been surprised by the intruder. Cusack just jumped to conclusions that his alerts were on.
Thank you. And why is this difference between your theory and Cusack's significant?
My theory is solid, and I know, and Cusack simply jumped to conclusions.
Thank you. Now, let's move on. What can you tell us about Avery Becker's phone?
Investigators used cell tower data to locate the phone, despite Becker having been separated from her phone, the night before.
Thank you. Now, at this time, the trial technician will display the 4th page of Professor Van Owen's expert report. Now, Professor, what does this graphic and the content of this page indicate about cell tower data?
Cell tower data is much less accurate than GPS data. Since we don't have the actual phone and we have to rely on cell tower data, we can never know if the phone was ever close to the victim's home. As you can see, each cell tower can reach up to 6 miles in each direction.
Thank you. And can you please just explain to the jury the basics of how cell phone tower data works?
Of course. Cell phones have the ability to connect to multiple cell towers. A phone is designed to connect to the tower that provides the best signal, not the nearest tower. Cell towers also cover a very wide area, and call detail records can't record the precise locations of the dozens of phones connected to a single tower at a time.
Thank you. And in this case specifically, how was cell phone tower data investigated?
Detective Markowitz only subpoenaed the cell phone tower records for a limited window of time, so we can only know that the phone connected with the cell tower somewhere in the area. There is no way to tell that Becker's phone made it from her house to Mr. Brackman's house just before the murder.
And can you please tell us more about how else Avery Becker's phone was considered in this case?
Well, since the prosecution only had one suspect in mind from the beginning, only cell data from Avery Becker's phone was looked at. A smarter thing to do would have been to obtain cell records from all of the phones in the area and to talk to anyone who had a connection with the witness or the victim. Especially important was Taylor Perkins' phone, considering that Becker was with Perkins the whole day of the murder.
Now, moving on, given what you saw during your investigation, is the prosecution scenario the most likely?
No. Blair Rowland's father was found.
Province of the jury. This witness can testify as to the evidence she collected, but she cannot tell the jury what evidence is stronger.
Yes, Your Honor. Professor Van Owen has thoroughly investigated the work the prosecution has done on this case, as well as conducting her own investigation, and she could testify to what she believes the most likely scenario is.
Response, Your Honor.
Yes.
Professor Van Owen can testify as to her criticisms of the police work, but she cannot testify to how likely that police work is in comparison to her own investigation. That is invading the province of the jury.
Okay. I will overrule the objection. She can testify as to which scenario or how she views the different scenarios or the evidence. What she cannot testify to, again, is the mental state of any individual. So you may ask that question.
Thank you, Your Honor. So would you like me to repeat my question?
Yes, please.
So do you believe that the prosecution's scenario after their investigation is the most likely given the evidence you've seen?
No. Blair Rowland's father was found guilty of murder when Mr. Brackman was defending him in court. This sounds like more of a motive than a little high school mock trial drama, right? Blair disappeared after graduation and is still off the grid.
Interesting. And can you please tell us more about Blair Rowlands and how he is related to the other students?
Yes. Blair was also close friends with Alex Cifuentes, who could have easily taken—
Objection, Your Honor. Foundation hearsay. The only way this witness would know about this is if she talked to Blair Rowlands or Alex Cifuentes.
Response, Your Honor?
Yes.
Having conducted an investigation on this case, Professor Van Owen would be familiar with all of the witnesses and possible suspects. She thoroughly reviewed the work of both Kyle Cusack and Detective Markowitz, both of whom had met with those people.
Your Honor, response?
Yes.
Kyle Cusack and Detective Markowitz have not met with Blake Van Owen Blair Rowlands, my apologies. And furthermore, the only way this witness would know if Blair Rowlands and Alex Cifuentes were friends is if she was speculating about that or if she had heard from someone else, which would be foundation hearsay.
Response, Your Honor?
No. At this time, I'm going to overrule the objection if it's contained somewhere and there's some evidence that she's reviewed based on her investigation. She may testify to that. If it is not contained somewhere, then I do think that's fodder for cross-examination. But at this time, I'll go ahead and overrule the objection.
Yes, Your Honor. So, Professor Van Owen, what else can you tell us about Blair Rowlands based off of what information you received during your investigation?
Yes. Well, I know that Blair was absent from school on the day of the murder. And we know that Becker and Perkins were at the mall during the murder. But nobody knows where Blair was.
Thank you. Now, moving on, what can you tell us about the phone screenshots brought forward by the prosecution?
The screenshots of the messages sent to the police by Alex Cifuentes were not questioned in the slightest. It is the job of the police to be skeptical. The Denver Police Department has the tools to run examinations on cell phones that could have verified or falsified this evidence, but they literally chose not to do the work.
So, given your expert opinion and what you've observed of this investigation, how do you view the work done?
There were so many errors on the prosecution's end. Not only did they investigate already considering Avery Becker guilty, they failed to obtain relevant cell tower records. They lost pictures of blood drops in the hallway. The digital file containing pictures was mysteriously corrupted. I don't suspect malice. I understand it was incompetence.
Thank you, Your Honor. No further questions.
Thank you. Cross-examination.
Yes, Your Honor. Ms. Van Owen, I'd like to talk to you about who's paying you today. In your entire career, having worked on 100+ cases, you have only ever worked for criminal defendants, isn't that right?
Yes. Well, since I make my living as an expert witness, a lot of prosecutors, use law enforcement personnel.
Van Owen, I didn't ask about that. I've asked if you have only ever worked for criminal defendants, correct?
Well, I have a better chance at finding work on the defense side since prosecutors usually use law.
Is that a yes to my question, Ms. Van Owen?
Yes.
And of those 100+ cases that you have done over the course of your career, you typically charge between $6,000 and $10,000 per case, don't you?
Objection, Your Honor. Relevance.
Response, Your Honor.
Response.
I am attempting to lay a foundation as to why she has a bias in this case and attempting to get at her motives for testifying.
All right, this time I'll overrule the objection. You may ask.
Of those 100+ cases, you typically charge between $6,000 and $10,000 per case, correct?
Yes, but I have to make a living. That's not the reason that I testify in these cases.
So over the course of your career, doing the math, that means you've made somewhere between $600,000 and over $1 million as a defense expert, in addition to your salary as a professor, correct?
Again, I testify because I want to see innocent people walk free.
I didn't ask about that, Ms. Van Noen. I asked if that is the amount of money you have made as a defense expert.
The amount of money I made is not important to me.
Now let's talk about your experience with the police department in Aurora. You were with that police department for only 9 months, isn't that right?
That is true.
And in that
with the
short
police
time, you were
department-
sued by someone you arrested, which resulted in a lawsuit that the city had to settle, correct?
Well, the police department was also sued because of the police department's.
Again, Ms. Van Noen, I didn't ask about that. I asked if you were sued by someone you arrested.
Yes, I was, because
And this caused you to become, in your own words, disillusioned with police work, correct?
Yes, the techniques I used to arrest this woman.
Now let's talk about the work you did and did not do in this case. You never actually visited the crime scene, did you?
No, I did not.
And you conducted what you called a partial investigation, correct?
That is true.
And for your partial investigation, you failed to get cell tower records for March 5th, 2020 to see whether Becker and Perkins were where they said they were, didn't you?
It is not my job to obtain cell tower records. It is the prosecution's burden.
But you admit that you could have and should have obtained these records, don't you?
It is the prosecution's burden, not my own.
You admit that you could and should have obtained these records, correct?
It is not my job to complete the case.
Professor Van Noen, if you would please turn to lines 122 of your witness statement, page 54. You did create a witness statement in this case, didn't you?
Yes, and I know that I said
Thank
that.
you. Now, if you would please turn to actually the last page of that witness statement. And when we get there, if you could just verify for me that that is your signature at the bottom of that last page.
Yes, that is my witness statement, and that is my signature.
And
I said
reading
that I
along
could have
with
done
me,
more for this case.
once we get to the bottom, Ms. Van Noen, reading along with me once we get to the bottom.
And I'm going to
I have carefully reviewed the statement. It is true and accurate. Did I read that correctly?
I think I heard an objection, actually.
It's not an objection. We cannot talk over each other, though. There is a constructive court reporter taking down the words of what each individual is saying. So let's try to make sure that we can get an accurate record with the witness and the attorney. Thank you.
Of course, Your Honor.
I apologize to interrupt. Go ahead.
Did I read that correctly, Ms. Van Noen?
What did you read? I'm sorry.
I've carefully reviewed this statement. It is true and accurate.
Yes, but after.
Now, if you would please turn to line 221 of your witness statement and read along with me there. 221. In hindsight, I could have also obtained these cell tower records for the day prior to the murder. Did I read that correctly?
You did.
Thank you. For your partial investigation, you also didn't try to get account records for Mr. Brackman's ring device, did you?
Still, it is not my burden. It is the prosecution's burden.
But you didn't do that, did you?
It is not my job to do that.
But you did not do that.
It is not my job to do that.
Professor Van Noen, I am not asking whether or not that is what you were hired to do. I am asking whether or not you did that.
I did not do that.
You also did not authenticate the text messages from Alex Cifuentes, correct?
That is the police's job.
Again, I'm not asking whose job it is. I'm asking if you did it.
I did not do that.
Next, let's talk about some more of your criticisms of police work. First, the scuff marks. You've stated that marks like that could have been left uncleaned by the homeowner for up to 5 years. Isn't that right?
Absolutely. There is no way to tell when these scuff marks were made.
And about that evidence, you have stated that it is the only apparent evidence of a struggle.
Yes. I believe that there was a struggle, but we don't know when the scuff marks were made. We don't know.
I'm sorry, I would like to clarify. You do believe there was a struggle in the home?
Let me answer your question. we don't know when the scuff marks were made.
You did previously just state, though, that you do believe there was a struggle in the home.
I am not sure. I was not there.
I can assure you that you did just say, I believe there was a struggle in the home. That directly contradicts your theory. Are you aware of that?
I am telling you, no, I don't believe that there was a struggle in the home.
You never mention a broken plate in your report, do you?
Sorry, can you repeat the question?
You never mention a broken plate in your report.
No.
But you heard the testimony today that there was a broken plate in the home?
Yes.
And you don't dispute that testimony, do you?
No.
You also heard the testimony today that there was an overturned chair in the home?
Yes.
But you don't mention that in your report either, do you?
No.
So you would agree with me then that actually visiting the crime scene could prove to be helpful in forming conclusions about what happened.
But it's not everything. The police missed
You believe that the
vital
broken plate also
information.
remained on the floor?
Objection, Your Honor. Objection, Your Honor. Badgering the witness, Professor Van Owen has been repeatedly cut off throughout this examination, and I would appreciate if opposing counsel would let her finish her answers.
Your Honor, may I respond?
You may.
Under cross-examination, I'm allowed to ask leading questions, which imply a yes or no answer. So once I get that answer, I am allowed to move on. If opposing counsel would like to let the witness elaborate further, she can do so on redirect.
I don't disagree with you, counsel. Again, I remind counsel, though, that this is a recorded procedure, meaning that we do have a court reporter that's required to take down the responses of the witness as well as the questions of the attorney. If you two are speaking over each other, we are unlikely to get an accurate record, and we do need an accurate record. So I would ask the counsel to keep that in mind as engaging in cross-examination questioning. Okay?
Yes, Your Honor.
You may continue.
Do you believe the overturned chair could have remained in the home for up to 5 years?
I do. I don't know what Mr. Brackman did with his home life.
How about the broken plate?
Sure, I don't know.
You've seen the videos of the intruder, correct?
Sorry, can you repeat that?
You have seen the videos of the intruder.
Yes, the ring videos are incredibly inconclusive evidence.
But it is your testimony that somewhere in those sweatpants and hoodie, the intruder was carrying a very sharp 12-inch chef's knife, correct?
Yes.
And it is also your testimony that the intruder who carried this knife into the house intending to kill Mr. Brackman left the murder weapon right there in the home, correct?
Yes, this is much more likely than the murderer taking the knife from the chef's block.
But you do admit that Mr. Brackman had a complete set of knives in a block with one slot missing, large enough for a chef's knife, correct?
Yes, but this knife that the prosecution claims did not match the other knives in the knife block.
Ms. Van Owen, you also heard the testimony of an open knife drawer in the home?
Yes, I did. But still, it is very unlikely that one of those knives would have been used to kill Mr. Brackman.
You admit that the size of the intruder matches the same build and body shape as the defendant, don't you?
The defendant has an average size and body shape.
Again, Ms. Van Owen, that is not what I asked. I asked if you agree that the size and build of the defendant matches the size and build of the intruder in the videos.
The intruder and the defendant both have average body size. Many people could fit that description.
You have previously stated that it is Investigation 101 not to assume things, correct?
Yes, and the prosecution repeatedly jumped to conclusions.
However, don't you state it is likely that Avery Becker's phone was deactivated?
Yes, well, since
you never investigated that though, did you?
It's not my job to investigate. It's the prosecution's burden of proof.
As a private investigator, it is not your job to investigate?
It's my job to prove my witness innocent. It's not my job to complete police work.
You also believe that the intruder carried the knife into the house despite there being no evidence to support that.
Yes, but how much evidence did the prosecution miss? I
I'll
feel
be
like
asking
my
you questions here, Ms.
theories are a
Van Allen.
lot more likely.
You also believe that Blair Rawlins could have committed this crime, correct?
It is much more likely that Blair Rawlins committed this crime. He had a much greater motive than Avery Becker ever had.
Professor Van Owen, you don't have any evidence that Blair Rawlins harbored resentment towards Mr. Brackman, do you?
Well, I think we can all assume that since Mr. Brackman failed to defend Blair Rawlins' father and his father is now in prison for life.
Again, I would like to remind you, you've previously stated it is Investigation 101 not to assume, but now you just stated, I think we can all assume. Did I hear that correctly?
Yes, but I think it's
no further questions, Your Honor.
Assumption. Okay.
Redirect.
Yes, Your Honor. Could I please have a brief time check before I do so?
I have 14 minutes, 33 seconds.
I have the same.
Excellent, thank you. So, Professor Van Owen, is what you get paid in any way important to the work, or in any way impacting the work that you're doing right now?
Absolutely not. I get paid so that I can have food on my plate and a house to live in, but I work so that I can see innocent people walk free.
Thank you. And when the initial investigators from the police department failed to do their work thoroughly, is it your job to fill in the holes and clean up after them?
No, it is their job to complete a thorough investigation. It is my job to defend my witness.
Thank you, Your Honor. No further questions.
Based on those two questions, any recross?
No, Your Honor.
Okay, thank you. This witness may step down. Are there any further witnesses for the defense?
Yes, Your Honor. At this time, the defense calls Ms. Taylor Perkins to the stand.
All right, Ms. Perkins, you may take the stand. You have already been placed under oath. You may begin. Thank you.
Good morning, Ms. Perkins. Could you please state your name and spell the last for the record?
Sure thing. Taylor Perkins, Perkins.
Now tell us a bit about yourself.
Sure thing. I'm a freshman this year at CU Boulder, which is really exciting. I graduated from CHS last year, Colorado High School, with some of my friends, which I was on mock trial team in high school.
And who were these friends in mock trial?
I was on mock trial with one of my very best friends, Avery Becker, which was a lot of fun. Me and Avery had a lot of fun in mock trial together.
Tell us more about Avery Becker.
Avery was definitely the best lawyer on the team. There was no doubt about that. Avery didn't have to put in a lot of work to succeed in mock trial. Avery was just a natural and didn't need to put in as much work as other kids. You could tell that bugged some kids on the team. Definitely including our coach, who didn't like how Avery had somewhat of a lackadaisical work ethic, but Avery's enjoyment and passion for the team definitely made out for that.
Could you tell us more about this coach?
Yeah, Coach Brackman was a great guy, and quite honestly, it's really sad to think that he's not here with us now. Him and Avery didn't always get along. He definitely wanted to see Avery succeed, and with that, Avery and him didn't always get along.
I apologize, I did not hear the objection.
I objected to speculation.
Response?
I believe that I've laid the foundation that Ms. Perkins has attended school with these people, attended mock trial, and has I've laid the proper foundation to ask this question.
Your Honor, no foundation has been laid for Ms. Perkins to testify as to how Mr. Brackman felt towards Ms. Perkins or toward Ms. Becker. The only foundation that has been laid is that they had observations of this, and this is not an observation. This is asking Ms. Perkins to testify as to Mr. Brackman's mental state, and there's therefore speculation.
All right, so again, I will overrule the objection as long as the questions remain in what you observed between the two individuals. And again, not particularly what an individual was believing, thinking, or feeling unless stated to you. You may continue.
Yes, Your Honor. To repeat the question, could you tell us more about this coach?
Sure thing. Coach and Avery didn't seem to get along all the time, which was quite honestly childish and foolish in my opinion. But this whole thing ending with murder from Avery from a little argument sometimes, there's no way.
Could you tell us more about this feud?
Yeah, they didn't always get along, and one time Coach got very upset with Avery because she was unprepared for.
This is still speculation, and she is testifying about Mr. Brackman's mental state, that he was frustrated with the defendant.
I'll overrule it as long as it's based on observation.
So from what I observed, Coach was upset with Avery, which ended up making Coach demote Avery to the B team from the A team right before or right after regionals when Avery was unprepared.
And then what did you do in response of Avery being demoted to the B team?
I ended up stepping down because I thought that was the correct thing to do, being that Avery was a good lawyer and Avery was my friend.
Was this a big sacrifice for you?
No, I did not enjoy mock trial as much as Avery, and quite honestly, being on the team was more of a social aspect for me. So there was no big sacrifice for me stepping down.
Was there any other events in this so-called feud that arose between Avery and Coach Brackman?
Indeed, one time I was not there, but Avery was very upset with Coach, which ended up having Avery wanting to blow off some steam and get back at Coach in a way.
I'm sorry, can you repeat your objection?
I objected to hearsay since Ms. Perkins was not on the team at the time this happened. Her only knowledge of this is through out-of-court statements being offered for the truth of the matter, so therefore it's hearsay.
Response?
Your Honor, I believe that this describes the action in which Avery took rather than what the statement was saying.
Your Honor, regardless if this was an action or a statement, the only way that Ms. Perkins can testify about this is through out-of-court statements that she heard about this event since she was not there herself, and so her knowledge of this is hearsay.
I'll overrule the objection.
Continue, Ms. Perkins.
Avery took what she believed to be a dry erase marker and wrote on Mr. Brackman's Porsche.
And what happened after that?
Coach was very upset and ended up kicking Avery off the team in whole, which I felt was quite unfair.
And what did this do to the team?
It kind of created somewhat of chaos with.
As we already established, Ms. Perkins was not on the team at this time, so this is still speculation as to what happened to the team afterwards, since she doesn't know of her own observation or knowledge.
I'll go ahead and overrule it. I don't know, it's speculation. If she's at least aware of it, how she came about that information may be of question, but at this time I'll overrule it. She can discuss what she's aware of.
Continue, Ms. Perkins.
With that, it created chaos on the team, and Avery tried to get back on the team, texting team members, including Alex Fuentes, which I was surprised by because Avery and Alex were not friends. Avery also went to Coach Brackman's practice to appeal the coach to get back on the team, which didn't work out in her favor. So to get Avery's mind off things, me and Avery went to the mall and hung out, walked around, went into the stores.
I'll sustain that. You can ask a question there.
And you and Avery spent time with each other. What happened while you guys were at the mall and the Fry Shack?
So we were at the mall and then we went to the Fry Shack, which during that time period, Avery had lost her phone.
And you say that Avery lost her phone. What did you guys do about that?
Yeah, so we didn't realize until the next day, which we ended up skipping school the next day to go and try and locate Avery's phone. We went through the stores that we had been in and back to the Fry Shack with still no luck trying to call it.
And did you see anyone that you knew at the Fry Shack?
Yeah, it was kind of bizarre. We saw some other team members, which we knew should have been at practice with Mr. Brackman, but they said Mr. Brackman never showed up, which now we know why.
And was anyone else gone from school that day?
Objection.
The day that mean
The only way that Ms. Perkins would know about anyone being gone from school is through out-of-court statements being offered for the truth of the matter, so her knowledge in this is hearsay.
Response?
Your Honor, I simply asked if there was anyone else gone from school on that day, not I believe that this is not hearsay because all of these people went to school together. They would know where people, their whereabouts.
Your Honor, unless Ms. Perkins had an attendance sheet in front of her and knew who was at school and who wasn't because of an official record, the only way that she would know whether or not someone else was not at school was through hearsay. And like opposing counsel stated, there were other people who knew about this, so maybe she talked to other people, but that's still hearsay. It's still foundation based on a hearsay statement about someone being out of school.
Okay, I understand the objection. Since she's not specifically introducing a statement, if she can answer whether or not she's aware if a student was at school that day. So that's overruled.
All right, to repeat the question, was anyone else gone from school that same day?
To my knowledge, another student named Blair Rollins was not at school that day, which created Blair was kind of weird. I won't lie. In my opinion, Blair was weird.
This doesn't fall under the question that was being asked.
Sustained.
Blair was kind of a weirdo at school, and Blair was also friends with Alex Fuente.
This witness is still testifying on that line of questioning. I asked that opposing counsel asks a different question in order to get this testimony in.
All right, I will sustain related to the character of Blair Rollins. I believe the question was whether or not another student was at school. Ms. Perkins has indicated she was aware Blair Rollins was not at school. So at this time, I'll ask counsel to ask another question. Thank you.
Yes, Your Honor. Ms. Perkins, who is Blair Rollins?
Blair Rollins is a student that I went to school with who was friends with Alex Fuentes. In my opinion, I think that Alex was definitely capable of having
improper character evidence, improper opinion, speculation, unduly prejudicial under Rule 403.
Okay, I don't know what her response is, so it's difficult for me to determine whether or not
Your
it's
Honor,
speculation.
I believe that this witness was about to testify about their belief that Blair Rollins was the sort of character to commit a crime based on the line of questioning and based on the response that she was about to give. And so I'm objecting on improper character evidence on that ground, improper opinion, speculation on that character evidence, and unduly prejudicial.
Okay, what I'm gonna do is I'm gonna let her respond, and then if you want to raise that objection, I'm just gonna hear the response at this time. Go for it.
I'm sorry, can you repeat the question again?
Who was Blair Rollins?
Blair Rollins was a student that I went to school with that was friends with Alex Fuentes and was around Alex a lot. And Alex was at the Fry Shack the night that we went there.
Thank you, Your Honor. No further questions.
Cross-examination.
Yes, Your Honor. Ms. Perkins, I have some questions for you as well. First, I'd like to discuss your relationship with the defendant as you testified on direct. First, you state that you are best friends with the defendant.
That is correct.
That means you spoke with the defendant frequently, doesn't it?
Quite often, yeah. We were also in mock trial and we went to school together, so I saw Avery a lot.
In fact, even after Mr. Brackman was murdered and you found out you were going to be a witness at trial, you and the defendant were able to get together and talk about the day of the murder, correct?
I was not told to limit my communication with Avery nor anyone else.
Ms. Perkins, I didn't ask whether or not you were limited, your communication was limited. I just asked that you were able to get together and talk about the day of the murder with the defendant afterwards, correct?
That's correct, because everyone at school was talking about it. I was sad.
As a matter of fact, you made sure your stories matched, didn't you?
I didn't need to make sure. Me and Avery were together and our stories did match.
Let's talk about Mr. Brackman. The defendant didn't like Mr. Brackman, did she?
Avery.
Objection, Your Honor. Pause for speculation.
Your Honor, Ms. Perkins isn't speculating. As we've already established, she had many opportunities to witness the relationship between the defendant and Mr. Brackman, and on their direct, she even testified as to their relationship. And so talking about whether or not the defendant liked Mr. Brackman is not speculation on Ms. Perkins' part.
And I'll overrule the objection if she knows based on her observations.
Ms. Perkins, you didn't like Mr. Brackman, did you?
I thought that he was an okay coach, but as a person, he was nice.
Well, let me clarify. Just like the defendant, you considered him a mediocre coach, didn't you?
That's true.
Just like the defendant, you considered him a bad lawyer in real life, didn't you?
That's true.
Mr. Brackman once demoted the defendant to the B team, correct?
As I stated in my direct, correct.
And you quit the team so the defendant would be back on the A team, correct?
I quit the A team because I felt as though Avery was a good friend and that was the correct thing to do. And Avery would also receive a better spot on the team, correct.
Ms. Perkins, I didn't ask whether or not the defendant would receive a better spot on the team. I just asked that you quit the team so the defendant would be allowed back on the A team, correct?
That is correct.
And because of her feelings toward Mr. Brackman, the defendant destroyed the paint on his car, correct?
Would you repeat the question?
Because of her feelings toward Mr. Brackman, the defendant destroyed the paint on his car, yes or no?
Avery trying to blow off steam, yes.
I was talking about whether or not the defendant destroyed the paint on his car.
Quite honestly, I'm not sure if it destroyed the paint on the car. I do know that it probably did damage, but did it destroy the paint on the car? I'm not sure of that fact.
Well, on the spot, Mr. Brackman kicked the defendant off the team, correct?
Mr. Brackman did kick Avery off the team, correct.
And because this was defendant's senior year, that means she lost her last opportunity to be on the team, correct?
That would be Avery's last opportunity to be on the team, correct.
Finally, let's discuss your story about the day of the murder. You have stated before that Ms. Becker is so connected to her phone that it is like her third kidney, correct?
As a teenager, what kid doesn't like?
Relevance.
Your Honor, this is relevant because opposing counsel's theory is that Ms. Becker lost her phone. And so testifying whether or not it was odd for Ms. Becker to be without her phone is extremely relevant to the testimony and to the story that they're trying to make for her alibi.
I'll overrule the objection.
Let me repeat the question. Ms. Perkins, you thought that Ms. Becker was so connected to her phone, it was like her third kidney, correct?
That's correct. As teenagers, we all love our phones and communication is kind of our life right now.
You know that her phone is never out of her reach, correct?
As is mine, correct.
Yet it is your testimony that the defendant left the fry shack without her cell phone, correct?
That is correct. Avery had gone to the bathroom, and after we left the fry shack, Avery probably didn't have her phone. And the next morning, we realized that Avery did not have her phone.
Ms. Perkins, I ask that you limit your responses to yes or no when I ask a yes or no question, unless you need to elaborate something. She also spent the whole night at her home without her cell phone, correct?
Yes.
She also woke up and got ready for school without even trying to look for her phone, correct?
Correct. We had a morning routine where Avery didn't need to text me to be able to come and pick me up.
Ms. Becker also picked you up at your house to go to school the day of the murder, correct?
Correct.
And only after all this...
Actually, that's not correct. We were not at school the day of the murder.
I asked if she picked you up at your house to go to school the day of the murder.
We did not go to school the day of the murder.
I didn't ask whether or not you went to school. I'm just asking that she picked you up to go to school.
She picked me up, not necessarily in terms to go to school, because Avery did not have her phone, so we went and looked for her phone.
Only after all this, only then did you two realize she didn't have her phone, correct?
We realized that morning that Avery did not have her phone, correct?
Finally, Ms. Perkins, you agree that the defendant had an inflated ego and can be rash, correct?
Avery at times did make decisions that were not the best for her, correct?
But you do agree, these are your words, that she had an inflated ego and can be rash, correct?
That is correct.
And in one of those rash moments with trashing Mr. Brackman's car, using your own words, the defendant needed to let off steam and freak Mr. Brackman out. Isn't that correct?
Correct. After getting demoted to the B team Avery senior year, she was upset and wanted to blow off steam.
No more questions, Your Honor.
All right, is there any redirect?
Yes, Your Honor, briefly. Miss Perkins, was quitting and placing yourself on the B team a sacrifice for you?
No, mock trial was
Beyond the scope of cross-examination, I never asked whether or not it was a sacrifice for her.
I'll overrule the objection. She may respond.
Being off the team was not a big sacrifice for me. Mock trial was more social for me, and putting Avery up upon the A team was a decision that I was willing to make for sure.
And lastly, despite the circumstances regarding the car, is Avery capable of murder over a mock trial dispute?
Objection,
No.
speculation.
I'll overrule it at this time.
I'll repeat the question. Is Avery capable of murder over a mock trial dispute?
No, vandalism is much different than murder, and I know Avery, there's no way.
Thank you, Your Honor. No further questions.
And based on those few questions, any recross?
No, Your Honor.
All right, thank you, Ms. Perkins. You may step down. And this witness can be excused. Does the defense have any further witnesses?
Yes, Your Honor, the defense calls Avery Becker to the stand. Ms. Becker, please state your name and spell your last for the record.
My name is Avery Becker, spelled Becker.
Why are you in court today, Ms. Becker?
I'm here today in court because I am being wrongly accused of the murder of my former coach, Mackenzie Brockman.
Could you be a little bit more specific about who Mackenzie Brockman was to you?
Mackenzie Brockman was my mock trial coach for the 4 years that I was part of the program at Colorado High School.
What was your relationship like with Mr. Brockman?
Although I respected his ability to get the team to a competitive level, Mr. Brockman and I personally did not get along very well. He often criticized my work and his perceived work ethic.
And how did Mr. Brockman criticize your work ethic?
Both verbally with hurtful and humiliating comments, and then also in the form of demoting me from the A team to the B team at one point.
Ms. Becker, can you please describe this demotion in more detail?
Yes, so I came into practice just like any other day. And when I got there, Mr. Brockman started yelling
Objection,
at
Your
me.
Honor. Calls for hearsay.
Response?
Any comments made by Mr. Brockman are out of court statements offered for the truth of the matter.
Sorry, I just cut out. Can you please repeat what I said or what happened after my question?
I objected on the grounds of hearsay.
On what was the hearsay?
It looks like the objection is to the statements made by the coach. And so she's objecting that those are out of court statements offered for the truth of the matter asserted.
Okay, Your Honor, response?
Yes.
Under Rule 803, the declarant is unavailable as Mackenzie Brockman is dead, and therefore this is an exception to hearsay.
Response, Your Honor?
Yes.
Just because the declarant is unavailable does not make the statements any less hearsay. Under Rule, did you say 803?
Yes.
Those exceptions are very specific. They mention nothing about whether the declarant is available or unavailable. Just because the declarant is unavailable does not make the statements any less out of court than they are right now.
Your Honor, response?
Briefly.
Your Honor, I believe the statement does not prove the truth of the matter asserted. It is simply recounting what happened in this occurrence between the defendant and Mr. Brackman?
All right, at this time, I'll overrule the objection under that they're not hearsay as they're not being offered for the truth of the matter asserted. You may respond.
Ms. Becker, how did you make it back onto the A team following this incident?
Well, my best friend Taylor Perkins took it upon herself to step down from the A team and mock trial as a whole in order to get me back on the A team a week before the regional mock trial tournament.
And how did you perform at the regional tournament? Excuse me.
As well and even better than I expected. I won the Best Closer Award and the Best Cross Award.
How did Mr. Brackman react to these accomplishments?
Objection, Your Honor, hearsay.
I'll overrule that. At this point, it hasn't clearly indicated a call for a statement.
Ms. Becker, how did Mr. Brackman react as you perceived to these accomplishments?
Well, you'd think that he would be proud of my accomplishments, right? Well, to me, it seemed like he was actually quite angry with me based on his facial expressions.
The only way Ms. Becker knows this, and as she stated in her testimony, is because of out-of-court statements that Mr. Brackman related to her. As such, they are hearsay statements and should not be testified about.
At this time, I'll go ahead and overrule if there's a specific statement that you think is being offered for the truth of the matter asserted. Please go ahead and reinitiate your objection.
Ms. Becker, would you like me to repeat my question?
Yes, please.
How did Mr. Brackman react to these accomplishments as you perceived?
Well, I hoped that he would be proud of me, but instead he seemed quite angry, and I believe he was angry based off of his facial expressions and some of the choice words that he had for me. And because I did not want to take these hurtful language and also the humiliation in front of my teammates, I left practice.
Ms. Becker, what happened next after you left practice?
After I left practice, I did the stupidest thing I have ever done in my entire life. Using a marker I still had in my hand from practice, I wrote across the hood of Mr. Brackman's white Porsche, Worst Attorney Award.
And how did Mr. Brackman react as you perceived when he saw this?
Understandably, Mr. Brackman was quite angry and immediately kicked me off the mock trial team permanently.
How did you feel after this incident?
As I just mentioned, this was a serious mistake on my part and something I regret every single day, especially since I was never able to apologize to Mr. Brackman properly.
Ms. Becker, how did you try to make amends for this mistake?
I tried speaking to Mr. Brackman in person at his office and texting him to try and explain the situation, but he was not receptive to any of these apologies.
Now, moving on to March 6th, the day of the murder, where were you on March 6th?
On March 6th, I was with my best friend, Taylor Perkins, the entire day, and we were searching for my lost phone.
What happened to your phone, Ms. Becker?
Well, the day before, so March 5th, I was with Taylor and we were at the Fry Shack and then later at the mall. And at some point during that time, I lost my phone.
Ms. Becker, where did you last see your phone?
The last time I can vividly remember seeing my phone is on a table at the Fry Shack. And this was the same table that a former classmate of mine, Alex Cifuentes, was sitting at.
Now, just to clarify, where you were not at Mr. Brackman's house on March 6th?
Absolutely not. Before this case, I had no idea where Mr. Brackman lived, which would make it absolutely impossible for me to be at his home.
At this time, I would like to direct your attention to the text messages supposedly sent between you and Alex Cifuentes. And have you ever seen these text messages depicted in these screenshots before?
No, I have never seen these text messages before. And in fact, it is quite presumptuous to assume that I would ever text Alex Cifuentes, considering the kind of person he is.
What do you mean by the kind of person Alex Cifuentes is?
Well, in my opinion, Alex Cifuentes was not the kind of person that I would ever want to be friends with.
Objection, Your Honor, speculation and relevance. Also hearsay.
Response?
Your Honor, I do not believe this is speculation, as this is the relationship that the defendant perceived between her and Alex Cifuentes, as well as this is not hearsay as it is not a statement.
All right,
Response,
I'll
Your Honor?
overrule the objection. No, at this time I'll overrule the objection.
Ms. Becker, what do you mean by the kind of person Alex Cifuentes is?
Well, in my opinion, and based on my observations of Alex, he was not the kind of person that I would want to be friends with, nor would he be someone that I would trust with the information contained in these alleged text messages.
Ms. Becker, what was your relationship like with Alex on the team?
Well, we were, of course, competitors on the mock trial team. And simply because I had a year more of experience on the mock trial team, Mr. Brockman often put me in better roles than Alex. So if I were not there, it is fair to assume that Alex would have
Objection,
gotten
Your Honor,
these roles.
speculation. The witness just said the word "I assume." It is most clearly speculation.
Response?
Yes, Your Honor, I believe that the defendant has spent enough time on the mock trial team, 4 years specifically, with the witness in question, or Alex Cifuentes and Mr. Brackman, to know the team dynamics and what would happen if she did not get these roles.
I'll go ahead and sustain, not as speculative.
Okay, I will move on then. Ms. Becker, if you're not friends with Alex Cifuentes, then who is?
Well,
Objection, Your
considering
Honor,
I went to school,
speculation.
I'll
This witness
overrule
has-
that if it's. I'll overrule that if it's based on her observations of who
Yes,
people are friends with.
Ms. Becker, at school, who is Alex Cifuentes friends with?
well, considering I went to school with Alex Cifuentes, I can say who he interacted with quite often, and that would be Blair Rollins.
How is Blair Rollins connected to Mr. Brackman?
Well, there was actually quite a famous trial
Objection,
case.
Your Honor. Hearsay and more prejudicial than probative.
Response?
Yes, Your Honor, this is not hearsay, as this trial is a matter of public record, and therefore the witness could have knowledge on this trial.
Response, Your Honor.
Briefly?
There is no public record exception to the rule of hearsay. Also, the only way this witness would know these statements is from statements made out of court that she heard from someone else. As such, they are hearsay. Also, any testimony about this is pure speculation and is also more prejudicial than probative and has no relevance to this case.
All right, I will overrule it on relevance. I will overrule it on 403. I will let her comment on the public record. If there's hearsay again being offered for the truth of the matter, you can re-raise the objection. Overruled.
Ms. Becker, how is Blair Rollins connected to Mr. Brackman?
Well, there was quite a famous trial that occurred in which Mr. Brockman represented
Objection,
Blair
Your Honor,
Rollins.
hearsay. These are obviously out-of-court statements that are being offered for the truth of the matter. This is a substantial part of the defense case. I am absolutely certain they are not offering this simply for the effect on the listener, but most definitely for the truth of it.
So I guess the truth of the matter is that Blair Rollins's father was being represented by the coach. That is public record. And as such, I will overrule for that piece of information that Blair Rollins's father was being represented by the coach. So overruled. Go ahead.
Once again, Ms. Becker, how is Blair Rollins connected to Mr. Brackman?
Well, Blair Rollins' father was sent to life in prison after his failed trial in which he was represented by my former coach, Mackenzie Brockman.
And Ms. Becker, how would you describe Blair Rollins physically?
Blair Rollins has a similar height and build as myself, and we have even been mistaken from behind for each other at school.
Thank you, Your Honor. No further questions.
All right, cross-examination.
Yes, Your Honor. All right, Ms. Becker, I have just a couple questions for you as well. First, about your relationship with the victim, Mr. Brackman. In your own words, you have previously said that you hated him, right?
I did not like Mr. Brockman very much.
But those were your words, that you hated him, right?
There were moments in which I did hate Mr. Brockman.
And again, in your own words, Mr. Brockman hated you as well, right?
I can't speculate as to how Mr. Brockman felt, but based on his actions, I can say that he also did not like me.
Let's discuss some of the reasons for this mutual hatred. You have previously stated that Mr. Brockman was always critical of you, right?
Yes, he was.
You've also said that his role was simply to attack you, right?
I believe he did attack me more than was necessary.
And Mr. Brockman would go nuts whenever you didn't do what he wanted, right?
Yes, I believe he was a bit of a perfectionist.
You argued with him at every single practice, right?
At almost every single practice.
Just basically the same thing. And Mr. Brockman always unfairly accused you, right?
In my opinion, yes, they were unfair accusations.
Mr. Brockman always said you were lazy, right?
He did mention those words, yes.
And you said to your adult coach that he wouldn't know a good cross-examination if it hit him over the head, right?
Yes, in a moment of passion, I did say these words.
And Mr. Brockman didn't just criticize you privately, he did it in front of the whole team, right?
Yes, this was slightly humiliating and also one of the reasons why I left practice.
And in addition to these bad feelings about one another, several times your relationship went farther than just words, right? We can pause the clock real quick, Your Honor. The witness has disappeared.
Same, I'll just give her a second to try to
I apologize. I believe I cut out of there. Am I back now?
I can hear you, I can't see you. Go ahead and continue examination. There she goes.
So, Ms. Becker, let's discuss some of these instances that you had with Mr. Brockman. Number one, before the regional tournament in 2020, Mr. Brockman demoted you from the A team to the B team, right?
That is correct.
Number two, when you won an award at regionals and Mr. Brockman criticized you, you called him the worst coach in the state, right?
Yes, I did say those words after he made very hurtful comments.
And then you took some sort of marker and drew in giant letters on his car, worst attorney award, right?
Yes, I did make that horrible mistake.
And by the way, Ms. Becker, I'm assuming that you know that an act like that is a crime, right?
Yes, Mr. Brockman, being the kind person that he is, did not press criminal charges, and it is something I am very grateful for.
And when he saw what you had done, he did immediately kick you off the team though, right?
Yes, this was very understandable, and I most certainly deserved this course of action.
And on that occasion, using your own words, he yelled, "What the hell have you done to my car? That's it. I have had enough of your crap. You don't work,
Your
you
Honor.
screw around in practice and are disruptive."
Objection, Your Honor, hearsay.
Your Honor, this is not being offered for the truth of the matter, but simply the effect on the listener in that it made Ms. Becker very angry.
I'll overrule the objection.
So just real quick, Mr. Brockman yelled at you, "What the hell have you done to my car? That's it. I have had enough of your crap. You don't work, you screw around in practice and are disruptive. You talk behind my back, and now this. I've had it. You are off the team." Were those his words?
Yes, Mr. Brockman did say those words.
Finally, Ms. Becker, immediately after you got kicked off the team, you went home and told your own mother that Mr. Brockman got mad at you for no good reason, right?
I did tell her this, yes.
So you didn't tell your own mother the truth. You lied to your mother, right?
I was in denial at that point, seeing as my mock trial career was over. So yes, I did not tell her the full truth, but we did discuss this later, and she is now fully informed of the situation.
But you did confess to her, and I quote, that you would get back at Mr. Brockman if it was the last thing you did, right?
In saying this, I meant that I would prove to Mr. Brockman that he needed me
Ms.
on
Becker,
the team,
we have
especially
very
to go
limited
to
time. Will
state.
you please just give me a yes or no answer?
I will explain where it is necessary.
All right, I believe the witness has answered yes to my question, and therefore I have no further questions.
Thank you. Is there redirect?
Your Honor, may I see how much time I have?
You may.
20 seconds.
Ms. Becker, just to clarify, what were your emotions and intentions when you said you would get back at Mr. Brockman?
At that time, I was very upset, and when I said those words, I meant that I would prove to Mr. Brockman that he needed me on the team and that he needed me in order for the team to go to state.
Thank you, Your Honor. No further questions.
All right, and we are out of time for recross. I will make a record that there was about a 5-second to 10-second give or take on your cross-examination when the witness did go out for the
Your Honor, at this time, the defense rests its case. Your Honor, I cannot hear you.
All right, am I back?
Yes.
All right. At this time, Ms. Becker can be excused. Are there any further witnesses for the defense?
Your Honor, at this time, the defense rests its case.
All right, thank you. Are we ready to go into closing arguments?
Yes, Your Honor.
Okay.
Yes, Your Honor.
All right, great. Then we will begin closing arguments. Prosecution, you may start.
Your Honor, before I begin, I would like to reserve any remaining time I have for my rebuttal.
That's granted.
Motive to commit mischief, which resulted in a murder. The defendant had a motive for getting into Mr. Brackman's house and vandalizing it. Once she was inside the house committing this crime, which the law calls criminal mischief, she was surprised. And although she did not intend to harm Mr. Brackman, a struggle ensued, and Mr. Brackman ended up with a knife in his back. His death is murder under the law. Good morning, members of the jury. My name is Rachel Kidder, and for the next few minutes, I will show you how the people have established beyond a reasonable doubt that Avery Becker is guilty of second-degree burglary and first-degree murder. First, under jury instruction number 8, the elements of second-degree burglary require us to prove that the defendant knowingly broke an entrance into or entered unlawfully in a dwelling with the intent to commit the crime of criminal mischief against another person or property. Criminal mischief means damaging the real or personal property of another person. Let's look at the evidence for burglary. The defendant had already vandalized Mr. Brackman's car and was planning something worse for the house. She outlined her intent to do so in the text you saw in Exhibit 14. You also heard the defendant tell her mother, "I will get back at Brackman if it is the last thing I do." The defendant's call detail records put her at the scene of the crime during the murder, and the ring security footage shows someone the same height and size as the defendant entering and exiting the home. The people have proven second-degree burglary. Next, under jury instruction number 7, the elements of first-degree murder require us to prove that the defendant committed or attempted to commit second-degree burglary. And in the course of that crime or in immediate flight therefrom, someone was killed. Here we've proven that the defendant's presence in the home was a second-degree burglary. The evidence showed that she was surprised. She may have even attempted to flee, but was stopped, a struggle ensued, and Mr. Brackman was killed. This, members of the jury, is textbook first-degree murder. When you review the jury instructions, you will see that motive is not an element of either crime, but it is an important factor in determining who did this crime, and we have shown you the substantial motive the defendant had by using her own words. You heard from Alex Cifuentes, Taylor Perkins, and even the defendant herself that she was criticized by Mr. Brackman, causing her to vandalize the car. She admitted that when she got upset, she did things she regretted. So when she was kicked completely off the team, she planned to vandalize the house as well. Today, the defense tried to tell you that the screenshots and cell tower data weren't enough to prove she was there. It is circumstantial evidence. We acknowledge that. However, under jury instruction number 3, the law treats both direct and circumstantial evidence the same. The defense also tried to tell you that the defendant lost her phone and didn't notice it was missing. Members of the jury, I would like you to think of all the teenagers you know that let their phone out of their sight for more than an hour. That list is non-existent, right? Finally, the defense brought to you an alibi witness, Taylor Perkins. Both the defendant and Ms. Perkins claimed they were together all day on March 6th. Jury instruction number 4 states you may believe all of the testimony of a witness, part of it, or none of it. You heard Perkins admit she stepped down from the mock trial team to give Avery Becker what she wanted. You also heard Perkins admit that she met with the defendant after Mr. Brackman's death. That's when they created their story and coordinated their testimony. Taylor Perkins is covering for her best friend, and you need to disbelieve her testimony. As for the defendant, you heard her admit that she lied to her own mother. And anyone who can do that can certainly give false testimony to this jury as well. Members of the jury, you need to disbelieve her testimony. There is no evidence for the alibi. The evidence that was admitted in this case shows us that the defendant's motive to commit mischief resulted in a murder. Members of the jury, it is not the people's burden to prove to you the defendant is a bad person. Of course, it's human nature to want to convict only bad people, but that's not an element of the crimes here. It's your duty as jurors to review the jury instructions and apply the evidence as the court gives you. The evidence did not show that the defendant intended to kill Mr. Brackman, but she did intend to commit criminal mischief and a death occurred. Members of the jury, after your deliberations, we request that you find the defendant guilty of second-degree burglary and first-degree murder. Thank you.
All right, thank you, Ms. Kidder. Ms. Hilden, do you wish to give the closing argument for defense?
Yes, Your Honor.
All right, you may begin.
Yes, Your Honor. So, may it please the court. Your Honor, members of the jury and opposing counsel. My name is Raina Hilden, and today, along with my co-counsel Cindy Nguyen and Maggie Holland, we have had the honor of representing the defendants of today's case, Avery Becker. At the beginning of this trial, my co-counsel Cindy Nguyen reminded you that the prosecution carries the burden of proof, meaning that they have to prove Avery Becker's guilt beyond a reasonable doubt. But today, they have ultimately failed to do that by jumping to conclusions and falling short in the end. We find through the witnesses that we have heard from today that not only does the prosecution's direct evidence fall apart, but their circumstantial evidence does as well. Because in every piece of evidence they claim to be true, we find reasonable doubt. And for that, you cannot convict Avery Becker. First, we looked at the actual investigation which took place from Detective Markowitz, Kyle Cusack, and Professor Blake Van Owen. Professor Van Owen highlighted for you all of the errors made in the prosecution's case. They had a lack of evidence connecting my client to the perpetrator who entered Mackenzie Brackman's home. All they could prove was that, yes, a perpetrator entered the Brackman residence and Mackenzie Brackman was thereafter tragically murdered. However, they could not find a single piece of concrete evidence to prove that that person was Avery Becker. The ring security videos show no identifying features outside of a general height and build. And I would like to remind you that my client is of fairly average height and build. In addition, there was no genetic evidence found at the crime scene to identify the perpetrator. Then moving on to the circumstantial evidence. The cell tower records that were collected by Detective Markowitz claims to locate Avery Becker at the scene of the crime. However, we find that Avery Becker had been separated from her phone the night before the murder, and thus the location of the phone and the defendant were not the same. Opposing counsel had recently claimed in her closing arguments that the loss of Avery Becker's phone would be unlikely. However, we saw that getting kicked off of the mock trial team entirely very deeply affected Avery Becker, and he wanted to prove that she could get back on it and be worth it to coach Mackenzie Brackman. In addition, the prosecution claims that Taylor Perkins and Avery Becker corroborated to form their alibi. However, the reason this alibi lines up is simply because it is true. The two friends talked to one another after the death of their mock trial coach because it was a deeply personal event, not to fabricate an alibi. So, members of the jury, looking at this, we see that there is reasonable doubt riddled throughout this case and that the prosecution has jumped to conclusions and ultimately fallen short, failing to prove that Avery Becker committed this crime. In Taylor Perkins' alibi, we find reasonable doubt. In the lack of physical evidence, we find reasonable doubt. And even the loss of evidence, images of blood splatters being corrupted during the investigation. Please consider the weight of this, members of the jury. Evidence was lost during this investigation, and while the prosecution claims that it was unimportant, we cannot prove that without this evidence. And finally, we find reasonable doubt in the lack of investigation into Blair Rowland. Kyle Cusack testified today that, yes, it is true that nobody could find Blair Rowland,
But that does not mean that Avery Becker, one of the only other suspects, had to be guilty simply because the prosecution could not find their other suspects. Members of the jury, please remember that in this reasonable doubt, you cannot convict Avery Becker. She is an innocent high schooler who has been wrongly accused of a murder she never committed. And for that, we ask that you come back with a verdict of not guilty. Thank you.
Thank you, Ms. Hilden. And Ms. Kidder, would you like a rebuttal?
Yes, Your Honor. Before I begin, may I get a brief time check?
I have 36 seconds.
I have the same.
Defense just stated that being kicked off the mock trial team very deeply affected Ms. Becker. They're right. It affected her so much that she committed murder. They also stated that the police made multiple assumptions, but you heard on Blake Van Owen's cross-examination, so did she. She contradicted herself multiple times during this case. Their entire case rests on the testimony of Taylor Perkins, who we have proven cannot tell the truth, members of the jury. We request that you find Avery Becker not guilty of murder. Thank you.
All right, thank you so much for both sides. That was amazing. I always am just super impressed. What we're gonna do right now is I'm just gonna give Ms. Cardone